rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. Let all who have cause to plead draw near, give attention, you will be heard. God save these United States, this great state of Florida, and this honorable court. Ladies and gentlemen, the Florida Supreme Court, please be seated.
Good morning. Our first case today is number 2024-0662, in re amendments to Florida Rule Civil Procedure 1.510 and new Florida Rule Civil Procedure 1.202.
Morning. May it please the Court, Cosme Caballero for the Civil Rules of Procedure Committee. With the Court's permission, I'm going to address 1.510 first and then 1.202. As I understand it, the genesis to the Court's amendment to 1.510 was an inefficiency or problem that was existing in the system where apparently litigants would file a motion for summary judgment. The current rules that exist today does not have a response time tied to the filing of the motion. So what would happen is if the litigant couldn't get the movement or the non-movement, they couldn't get the hearing set, this motion would just kind of linger and sit out there into, for potentially cause issues for the trial judge in the setting of the case for trial, et cetera. So what the Court did was, in response, it drafted a rule that tied the response time to the filing of the motion. And that does fix and should fix that problem that we're talking about. When the committee looked at it, though, what ended up happening was the current rule that's proposed by the Court eliminates the sort of the coupling or the tethering of the motion to the hearing. And when we looked at some of the consequences that can flow from that, what we realized was when you eliminate the link to the hearing from the motion, you have a situation where the movement can potentially set the hearing very close in time or within the response time. The rule as proposed actually doesn't prohibit that. So you have a situation where you can have a movement file a motion for summary judgment today as proposed in the Court's rule, and the non-movement has those 60 days to respond, but what ends up happening is the movement sets the hearing on day 61 or 62.
Can I ask a question? And
Yes.
This might be kind of a silly question, but how would they set the hearing without conferring? How would they unilaterally set this hearing without the other side realizing?
Sadly, that unilateral setting of hearings unfortunately happens. It's not professional conduct, but those type of things happen.
But wouldn't that be grounds for that hearing to not go forward?
It would be, and then that's where you get into some of the consequences the committee was worried about, which is motion practice dealing with prematurely set hearings, motion practice dealing with folks that aren't conferring about setting the hearing. What we don't want to do is have trial judges burdened with this sort of collateral litigation about, or these collateral hearings about matters dealing with the scheduling of the hearings.
Why not?
Because it's a waste of time.
I don't think so. I mean, if all a trial court judge has to do is deny the motion to set the hearing for failure to include a conferral statement. If there's no meet and confer statement, it's denied.
Well, no, the problem that happens with the scheduling of the summary judgment hearing is that somebody prematurely schedules it. You have to bring it to the attention of the trial judge. And in that process, you're talking about getting the trial judge engaged, getting a motion calendar hearing set potentially, or even sending emergency communications to the judge.
So what if the rule provided that any proposed hearing that is not accompanied with a meet and confer statement is subject to summary dismissal or summary denial?
You're talking about the conferral rule? Or
yeah. No, I'm saying if you want to set a hearing on a dispositive motion and it doesn't include a meet and confer statement, it just gets denied. You don't get a hearing.
As a penalty for but you're talking only within the 1.510.
Yeah, I mean, for today.
Okay. I mean, that's potentially something that could be added. I think it fits better within the conferral rule, honestly, because it's part of that process. What the committee proposed on the 1.510 and the 60 days, by the way, I think a lot of people felt it was too long of a period of time because sometimes you have these motions backing up into the trial setting or the calendar call. So all of this is obviously governed by the case management order. If you have a 60-day response window, now you're expanding the amount of time for these case management deadlines, and we want to, per the court's sort of decision to implement the differentiated case management process, we want to move the cases quickly. The 60 days was seen as too long.
Can I ask you a quick
Yes.
question? I'm sorry to interrupt you because I want to make sure you get to the conferral thing. So a lot of the comments, I think, rightly flag this problem potentially of us not having thought about people scheduling the hearings this way. One of the other approaches was to make the response due, 30 days, 40 days, 60 days, whatever, and then just say that the hearing has to be at least 10 days, whatever, after that. Does the committee do you have any problem with that approach?
No, that's the approach we propose.
I know you guys did it kind of in two separate places or whatever, but if we just said, motion gets filed, response is due however many days, and then the hearing can't be any less than 10 days after that, you'd be okay with?
Yeah, that's exactly the concept the committee proposes. I think it works to tighten the time frames and ensure that the trial judge ultimately has enough time to review whatever they need to review in preparation for the motion.
Okay, so if you want to just go ahead and address the conferral.
Yeah, the 1.202, I'll start by just saying that's a great rule. Everybody is in favor of this. There's no question. Everybody wants more conferral, more transparency in the process, no doubt. When we looked at the rule as a committee, we were concerned about basically three concepts. One was, are there a certain set of motions that should be exempt from the conferral process? Number two, how to treat pro se litigants or self-represented folks. Number three, what to do about sanctions if there's non-compliance with the hearing, and I know that's something that Justice Curiel just talked about. With regard to self-represented litigants, generally speaking, there was wide consensus that, unfortunately, folks that are pro se are going to struggle with this concept. They don't understand necessarily what it means to confer.
Do you know how the federal district courts in Florida address that in their standard operating procedures or in their local rules?
Yeah, the Southern District, I don't believe, has pro se litigants conferring. I believe the Middle District does not apply to folks in custody, if I'm not mistaken. Mm-hmm. And I can't recall off the top of my head the Northern District. But there's some level of variability in it. In terms of what we proposed is, let's exempt out the pro se litigants. If the movement is an attorney, they will still confer or attempt to confer with the pro se litigant. How successful that'll be, we don't know, but they'll attempt to do so.
Let me ask you this.
Yes.
It seemed like when I was in trial court, General Civil Division, most of the cases that were before me daily were these uniform motion calendar cases where if you just send a certificate, a notice of hearing to opposing counsel, and you go outside and you sign up on the outside the courtroom, and the judge hears you, and each side gets 5-10 minutes, whatever. It seemed like that's the bulk of what I did every morning. And of course, I'm trying to get through all those cases because I got a trial going. I want to start up at 9:30. I got an expert on the clock that the other side put on the day before, and all that pressure's going on. So my concern in dealing with all these rules that we're doing here is that we seem to be using the federal system as a model on how we should do things in the state court system. And the federal system is a completely different world. Resources, they have tremendous resources. They don't have uniform motion calendar hearings. You file a motion, you send it to the judge along with your memo, and if the judge wants to hear from you, he or she will let you know. But that judge doesn't sit up there from 8:30 until 10, hearing case after case after case, with lawyers just come in. And my concern is, and the caseloads, obviously, when I left, I think I had 800 cases to my name. Now, we're talking thousands of cases to my name. And every single day, lawyers are not getting answers to interrogatories. They're not getting answers to request for productions. They want to object to answers. They want to do this. They want to do that. Every single day, we have to deal with that. And all I keep hearing is, how do we do it in the federal system? But I wish we could do that in our courts. You can just send out, hey, write me a memo. I got 5 law clerks back there, and they're going to look at them, and I'll let you know if I want to hear from you. But we don't have that here. And we're creating these deadlines and this notice to confer with the other side, and that's nice. That's nice, but when you're in a hurry to get these things heard and all these discovery things that are holding up the case, it's not feasible in the state court system. And that's the problem I'm having with all this revamping of rules, that we keep going to the federal rules. What can you tell me about that?
Well, what I would say, Justice Labarga, is that the committee, when we look at these rules, we're very cognizant of the resource issues and the difference between the state court trial judges and what resources they have and the federal court. We try to strike a balance in terms of how to approach them. With our conferral rule, I think we've done that. We looked at our state court conferral, some of the state courts, how they do it. We looked at the federal courts, how they do it. And we try to come up with a balance that works. The conferral rule, to address your concern, I think it should facilitate and help some of these discovery disputes. It's not uncommon that people, don't confer, and then in the last minute, the day before the hearing, they realize, look, we can actually resolve some of these issues. So hopefully that's what this conferral rule does. We wanted to make sure to exempt certain types of motions that should not be subject to conferral, which are the ones that basically happen on an ex parte basis or without notice, or have some kind of emergency component to them, like injunctions or collection type motions. So that's part of what we put together. And then we have in terms of the sanctions, the committee felt that sanctions were not appropriate because all it would do really is just engender litigation about sanctions in terms of the conferral. There's a place and time for litigating about sanctioning misconduct. What we don't want to do is spend judicial time and effort dealing with conferral issues. The trial judge can oversee their division, the lawyers before them. It's really more of a professionalism issue.
And don't you think the trial court has the discretion on the sanctions issue, and also sort of related as the good faith issue? So some of the comments have suggested that the good faith requirement in the conferral section should be given more teeth. Do you have a response to that?
Yeah, I agree 100%. I think the trial judge has discretion to oversee their division, the lawyers before them. It's part of that, what I think judges do. And to have a hearing where litigants show up and fight about a conferral and take up the judge's time, to have sanctions entered against each other or one or both, is really
I guess what I'm not following is, why is it not that the natural sanction is that whatever the movement seeks is denied without prejudice until this is refiled with a certificate of conferral? Why is that not?
Yes, I mean, that could be added, assuming it's the movement who's the party that's not conferring in good faith. You're still going to get into issues about dealing with whether there was conferral, whether people made those efforts. But yeah, you could certainly add that. It wouldn't change the dynamics. I think the conferral rule is the aim, and what it wants to do is a good thing. And I think it should work. It should help. I would ask that the court adopt the committee's version, because we went into quite a bit of detail in terms of what should be left out, and it's a good rule.
Could I ask a quick question?
Yes.
Was there a general consensus that 40 days was sufficient for a response in the summary judgment versus 60? It's pretty rare that we see lawyers saying we need less time to respond.
I think a lot of the discussion that occurred had to do with how does this time frame work within the broader case management picture in terms of the trial setting and then working backwards. I think that's where a lot of the impetus came to change it from 60 to 30. Are you going to have problems changing the time frame and shortening it? Are you going to have issues with premature motions for summary judgment and how to deal with those? I think so, but that would happen probably under the court's version, that's 60 days. If somebody files a premature motion, you're going to have those issues anyway. So,
Thank you.
Okay, thank you very much.
Thank you. Thank you.
Appreciate it.
Good morning. May it please the court. My name is Megan Luca, and I thank you for inviting us back. I will follow Mr. Caballero's lead and start with 1.510. I think that you have to say that the deadline for filing the motion must be set by court order. That was something that I proposed in my rule. The version that the court proposed said that it must be filed by the deadline in the case management order. The case management order that the court selected, Track A, doesn't have a motion for summary judgment deadline. So I think the rule just needs to say that it will be implied that the court has to set the date. For example, in Hillsborough County, our case management conference orders are automated. That doesn't have it, but that doesn't mean that Judge Moe won't put it in an order, and it will definitely come out in Hillsborough's trial order, which comes a few months after the case management order. Here's your deadline for summary judgment. So I think it is a nitpicky thing, but it's an important thing. I think the majority of commenters agreed that you need to have a 10-day buffer between the response and the hearing. And Justice Coriel, it is true, litigants do unprofessionally manage to set hearings sometimes, and then it becomes a pain in the neck for the judge because now the judge is having to deal with an emergency motion to strike a hearing.
Litigation is a pain in the neck for everybody involved. Pain in the neck does not move my needle.
Well, I am hoping that the other factor might move the needle, which is part of the reason that the court changed the summary judgment rule in the first place is because it used to be that the parties could file their materials 2 business days before a hearing. If you were a trial judge and you had a massive motion for summary judgment, 2 days was not sufficient to review the materials. That was part of what this court was moving towards, was a situation where the trial judge wasn't going to get pantsed by a last-minute filing. And so the 10 days is, in my opinion, designed for the protection of the trial judge, to give the trial judge time. In my suggested rule, the trial judge could waive that, but it's meant to protect them so that they have time to review the materials, and honestly so that the moving party has time to review the materials. Because the moving party files, there's a response, and that 10-day buffer means the judge has time and the moving party has time, so that when you have a hearing, it's an education, it's a hearing where everybody's prepared. This is one that I feel so strongly about. You have to have a tolling provision in Rule 1.510D. That is the provision that says that if the moving party files a summary judgment motion and you think it's premature because not enough discovery has been completed, you can file a motion with the court. It must include an affidavit. It must explain what discovery you believe is necessary and why you think it would change the outcome of the case. The problem that I foresee is that the rule currently says nothing about what happens when you file that motion. In today's version of the rule, if I filed a motion for summary judgment and my opponent filed a motion under 1.510D, there would never be an agreement on when a hearing would be set, and nothing would happen. My opposing party wouldn't have a response due until the court ruled on this motion to extend the deadline because more discovery needs to be conducted. Under the new version of the rule, my opposing party files a motion for summary judgment. I say, wait a minute, the case is 30 days old. Nobody's conducted discovery. Your Honor, here's my motion. I need to take these 3 depositions. They're determinative on the issue. Please toll the deadline for filing. Okay. If I conferred about it, I had 40 days, let's pretend, to respond. Now I only have 36 days because I conferred on 3 separate days. In most of Florida's jurisdictions, the odds of you getting heard by a judge within 36 days are slim to none, which means I've got a motion sitting out there asking the court to extend the deadline while my deadline runs. You need a tolling provision so that when the court reaches that motion on day 50, if the judge grants it, then they'll put a new deadline in there. If the judge doesn't grant it, then your time for filing the response was told, and now you've got whatever time passed between when you filed your motion and when it was ruled upon in order to file your response. That sounded like a lot of words. I'm getting a lot of blank looks. Did any of that make sense? This is so important. And it's honestly how it works in the DCAs. If you file a motion in the DCA, all deadlines are told until the court rules on it. So
It makes sense, but I guess it has a whiff of potentially creating another sort of black hole type situation where, I understand what you're saying.
the black hole is unavoidable due to lack of hearing time, but that is not the fault of the party who's saying we need to conduct more discovery. And what will happen if there is no tolling provision is that trial judges are going to be faced with a situation where they now have to decide, well, what did it mean when they filed the motion? I couldn't give them the hearing time, and now under the rule their deadline for responding has run. The rule will not function properly.
I guess my blank stare is a little bit about so what? Like, if the party has to assume that they're not getting the relief they sought and has to just live with the assumption that their motion is going to be denied, which, by the way, I find is a very healthy assumption to go about any motion. So what? The party's is supposed to just be ready for the date that the court has set.
Justice Curiel, when someone files a motion for summary judgment 45 days after the case has been filed and no deposition has been taken yet, if you are the non-moving party, so what? Is a horrifying question. It's case dispositive. If you haven't been able to take a deposition, and the deposition of the defendant's corporate representative is designed to elicit the testimony that will destroy their motion for summary judgment, you should absolutely be allowed to take that deposition. The federal rules contemplate it. It happens all the time in federal court and state court.
Well,
so the so what
obvious,
is critical.
But wouldn't it be obvious if someone is not conferring in good faith if there's no sort of statement that the parties have worked on a deposition schedule to accommodate the summary judgment schedule? Won't that be obvious to the trial court that someone is stonewalling and that is a reason?
Your Honor, there is no conferral requirement in any state court or federal court of which I am aware for a dispositive motion.
No, not for the summary
agree.
judgment schedule, for the discovery schedule. You're talking about, I can't take a deposition because I don't have enough time in my summary judgment window. I would expect that the parties would have met and conferred about the deposition schedule, about the discovery schedule, about jurisdictional discovery. I would expect to see that if I'm a trial judge before the summary judgment deadline. Am I wrong?
So, Your Honor, currently, no case management order is required to be issued until 120 days after the complaint is filed. If someone files a motion for summary judgment, which they're allowed to do 20 days after the case is filed, you have a 100-day window before you even need a case management order. So I'm talking, this is directed to primarily cases where there are premature motions for summary judgment filed. And if I'm the trial judge and I'm looking at it and I'm like, okay, they complied with the rule. They filed their motion for summary judgment 30 days after the case was filed. No discovery has been taken. Our response is due within 40 days. They filed a motion and they asked me to extend the deadline so they could take the depositions, but I couldn't get to it in time. So now I'm going to grant summary judgment against them because they weren't able to get that deposition taken?
No, you would deny it without prejudice.
But, Your Honor, why have Rule 1.510D if what you are proposing is the method for it to be handled? 1.510D says if I want to oppose a motion for summary judgment by saying we have not had an opportunity, the other side is stonewalling me, the mechanism that the court created in Rule 1.510 is subsection D. You have to come forward with an affidavit and you have to make a motion. Your response to a summary judgment motion that's filed too early can't be, I'm just going to tell the judge that I'm not ready yet and the other side's stonewalling me. I don't disagree with you. It is a judge should be able to deny it under that circumstances. And 1.510 gives them that. That is one of the 3 or 4 remedies that is offered in that rule. What I'm telling you is that you created the mechanism already. It's 1.510D. It requires an affidavit. It has procedures. And to be consistent and make that rule effective, it needs a tolling provision. I think that the response time should stay 40 days. People are used to 40 days. If they need more time, they can ask for it under 1.090. If it's just a matter of, I've got a trial and I don't have enough time to write it, which is different from I haven't had enough discovery yet. If I just need 10, 20 days more because of schedule conflicts, that's a motion under 1.090. 40 days means that people who are paying attention and they need a deposition and they can get it scheduled don't have to pay for expedited transcripts. I got to tell you, from the trenches, an expedited transcript is expensive. It is twice as much, literally, sometimes 3, depending on who your court reporter is, to get it that fast. And the rules are supposed to be interpreted to deliver just, speedy, and inexpensive justice. So it's actually a practical requirement. If you make it shorter than 40 days, I think it'll just lead to increased motion practice asking for extensions. And there's another practical consideration. A lot of people file motions for summary judgment right before mediation. And it's kind of about what their position is, because they want to go to mediation and they want it to still be sitting out there so that it's a method of intimidation, and you don't want their response to be due yet. And you need the 40 days in order to make that strategy still function. And in my opinion, it functions well.
Ms. Luca, you think that the 40 days, though, is better than the 60 that we originally had in this proposed rule?
The only thing that, look, I'm an appellate lawyer, and I love me some extensions of time. I use them liberally. I would probably be the one who writes the motion under 1.090. But if you're trying to move things at the speed with which you're trying to move them, and you want to be able to have motions for summary judgment resolved, you got to do the math and you got to work backwards. So if the motion for summary judgment needs to be resolved before trial, and you want to give parties 40 days, and you got to have 10 days before a hearing, now you're 50 days out from trial, which is almost 2 months. In my mind, I'm thinking, all right, now if I want to give somebody the ability to ask for a 10 or 15-day extension of time, now you're about 2 months out. It's about working backwards and giving the judges the time that they need to be able to get the motion for summary judgment ruled on, but also getting it close enough to trial so that you don't have to file the motion under 1.510D and you actually have taken the discovery. There is a sweet spot, and it's hard to find. And then the last thing that I would say is, please, for the love of all things holy, tell us how it works. If the rule goes into effect on January 1st and somebody files a motion on December 15th, how does it work? I would argue it's procedural. It only applies to motions that the new requirements, timing requirements in 1.510D only apply to motions filed on January 1st or later. But I'm begging you, write something, because otherwise it is going to be chaos, and you're going to get judges interpreting it very differently, and it's going to cause delay because it's going to take a year for the DCAs to decide if it's even a final judgment. So
we want to limit our chaos causing to the unknown unknowns, or
yes.
whatever.
And I went long on that. I'm very sorry. I'll go as quickly as I can through 1.202. Justice Labarga, I hear you on the federal rules. I agree with you on a lot of it. On the conferral rule, I actually support that one, because a lot of times people can be paper tigers. They are just obstinate studs in their written product if you're emailing about it. But it happened to me last week. We were fighting over corporate representative topics, and on paper, he would not budge. We got on the phone. We had no disputes left. We agreed on every single topic. So the motion to compel that I had filed became moot. And
What happens if your opposing counsel doesn't respond when you're calling, asking to confer? What happens if he or she doesn't respond?
absolutely anticipated that in my version. You get to write in your certificate of conferral that I attempted to confer with them. I suggested that it should be 3 times. That you should have to, you can do it twice by writing, but honestly, email's easy to miss. I think once should be a phone call. And at 3 times, you get to write, I tried emailing them on Monday, I tried emailing them on Tuesday, I left a voicemail with a receptionist on Wednesday, no one responded to any of my attempts, so I'm still filing my motion. The judge doesn't get to deny it at that point, but the judge, in my opinion, should absolutely be able to call the opposing party to the mat and say, I'm about to sanction you unless you can explain to me.
So how would the trial judge do that? Would the judge schedule a hearing and have opposing counsel and you come in? So
let's say you file your motion and you've got to have a certificate of conferral, and your certificate says, I tried 3 times and they wouldn't talk to me. I'm the judge, and that motion, let's say it's a motion to compel, gets set for hearing, and I'm the judge and I'm reading it and I flip back and I see on the conferral that the other side didn't respond. I need to address the merits of the motion to compel, and then at the beginning, at the end, I don't know, up to the judge, Mr. Labarga, explain to me why it was that you did not respond to this motion. Explain to me why I shouldn't just grant it for your failure to respond. That is
why I shouldn't treat it as unopposed.
And that should be left to the court's discretion. But I absolutely think that if you fail to respond to 3 attempts to confer, it's something the judge should know about, and it's something the judge should have the discretion to deal with how they see best.
So you don't see that the failure for the non-movement would cause any more hearing, because it would just be kind of part of the main motion?
Yes, Your Honor.
But for the other way, for the failure to even attempt by the moving party, what kind of additional work do you see that creating for the trial judge, which I think is Justice Labarga's concern?
Honestly, I think that is going to be a judge-by-judge consideration. I would suggest a CJE that recommends to the judges that they themselves, through whatever the function is in their individual chambers, whether they have a JA, a case manager, whatever, that the first thing they need to do is look at the certificate of conferral, and if it's not there, dismiss it.
Prejudice.
Deny it without prejudice.
So no
don't even reach it. And all of a sudden you've got 10 more minutes on your hearing calendar. And I think that I personally love Rule 1.202. I have 2 teenage daughters, and I am always reading. I've got Thrivers in my backpack right now. I'm reading The Anxious Generation. The objective data exists that the more time people spend on devices, the less connected they become as human beings. We've lost that connection because we don't sit in the pews outside judges' courtrooms anymore. We don't have to talk to each other. I love the conferral rule because it requires you to talk to each other. And I think that it's super important. And I think that it's important that we get it right. And I personally disagree with a lot of what the Civil Rules Committee proposed. I think that, and I was not able to be there for the meeting when they discussed it. Not that me being there would have changed the outcome, but it was done very quickly in order to be ready. We have a procedure, you have to go through the Board of Governors, it takes time. I would request that you answer 8 questions. And I'll tell you what they are. I'll put them in writing and send them to you after the oral argument if you want. I think you need to answer 8 questions, and I think you need to send it back to the committee. And I think you need to ask them to respond with a proposal on an expedited basis. We've proven to you that we can do it. And I think that will allow us to get the rule right. And Mr. Caballero won't toot his own horn, so I'll toot it for him. As our chair, he had all of the vice chairs reach out to every chief judge, and we asked all of them, I don't know if you watched the Hunger Games, we asked them to make a tribute of a judge. And one judge from every circuit is available to serve ad hoc on our committees for issues like this. So we get judicial input, you get the input of lawyers who are in every walk of practice, and you need that kind of vetting and that kind of thorough analysis in order to get this rule right.
This whole process has been going on about 5 years?
Well, this one only came up when you submitted this one was one that was created by you, and I think it went out in July, if I'm not wrong. So this one's a baby.
Is that the first time this issue came up?
This conferral rule?
Right.
Yes, Your Honor.
So what are the 8 questions?
Number 1, are you okay with a long list of exemptions? Because I think there are things that do need to be exempted. I don't think that you should say it only applies to discovery motions. I personally think you need a long list. Do you want all motions to dismiss in specific to be on that list? There were several commenters who talked about all motions to dismiss. Personally, I don't think all motions to dismiss belong on there. I think at least 3 do. I think that you should consider it. There are 6. Do you want the Civil Rules Committee to identify all of the places in other rules that are impacted by creating a conferral rule? For example, there's a conferral requirement in Rule 1.201. There is a conferral requirement in 1.380. There's a conferral requirement in, I didn't write them all down.
We get the point.
Yes. So if you send it back to the committee can provide you with a full package that creates both a 1.202 that's been thoroughly vetted plus a suggestion for how to address so there's no competing provisions. Number 3, do you want to delineate minimal conferral requirements, or do you want to leave that to the discretion of the lawyers? I am typically in favor of shorter, less complicated rules, but I'm afraid that my idea of a conferral requirement and somebody else's idea of a conferral requirement aren't going to be the same. I personally am in favor of minimum requirements. Do you want to require conferral with unrepresented parties? The Civil Rules Committee suggested what I would give the example of if I filed a motion or if I wanted to subpoena medical records from a doctor and the opposing party opposed that and the doctor is unrepresented, the doctor has no dog in the fight, they just tell me whether I got to send the records or not. Under the Civil Rules Committee's proposal, the person who wanted the records would have to call the doctor's office to confer with them. And if the doctor's office hires a lawyer who enters an appearance, you got to confer with that lawyer. But otherwise, who are you talking to at the doctor's office? What are they going to say? I think it's unnecessary. Number 5, do you want to say the rule is a floor and that trial courts can make additional requirements? I think that you do want to say it's a floor. I don't think that you want it to be the ceiling and that if a trial judge has a specific method that's been working for them, that they shouldn't be able to include another detail. Number 6, do you want the rule to have a certificate of conferral form? The Civil Rules Committee said no. I personally think that when you give lawyers a form and you tell them these are the words you got to use, they're grateful. They're busy. Just tell them what it's got to say. The judges will get used to seeing the form. I'm pro form. Do you want the certificate to indicate what was agreed upon? The Civil Rules Committee wanted the parties to have to list in the certificate what was agreed upon. I think that's busy work, and I think if I'm a trial judge, I'm looking at the motion and I've got 10 minutes, just tell me what you're fighting about. That's awesome that you figured it out on some stuff. I don't need you to tell me what you figured out, just tell me what you didn't figure out. And do you want the motion to indicate that no conferral was necessary because it was an exemption? I think you absolutely do want it. Justice Coriel, I think that you would support that too, because you want the judge, when they flip to the end, if they don't see a conferral requirement, if they don't see something that says no conferral was undertaken because this motion is exempted, the judge might, deny your motion. So I think you should require the parties to say if they were exempted. Number 7, do you want a sanction for failure to confer? I think you do. Justice Coriel, I think sanction is, you're forewarned. You have to do this. And if you don't, then your motion's going to get dismissed without prejudice. You're going to have to get back in line. Make it clear so that the lawyers who choose not to follow the rule do so at their own peril. And number 8, do you want a comment to give parameters to the meaning of the word good faith? I attached to my comment an article that collected all 3 of the federal rules and as many circuit rules as the authors could find, and the common thread seems to be that they said that to confer in good faith requires a substantive conversation with an exchange of ideas. An exchange of ultimatums by email, text, or letter does not satisfy the requirements of this rule. I don't know that that belongs in the text, but I think that this might be the rare instance where a comment makes sense.
Okay, these are all well taken, and I think we'll obviously think about your idea about sending it back. I mean, all of these things are kind of a work in progress, and so we may just sort of take a stab at, because a lot of these things that you're identifying as questions are things that we've gotten different approaches to in the comments. So we may take a stab at resolving some of this stuff, and if we do it in a way that people think could be improved, then the committee will always be there to continue to suggest refinements. But everything that you've said makes sense, and we appreciate the input a lot.
Thank you, Your Honor.
May it please the court, good morning. My name is Russell Landy, and I'm here on behalf of the business law section of the Florida Bar. Mr. Caballero and Ms. Luca have very eloquently stolen my thunder on a lot of what I was going to say, but we, as a section, certainly support a deadline. A 60-day deadline is fine. 40 might be fine, but we're okay with the 60-day deadline, but find it very important that both the motion and the response are tied to the hearing deadline. Because you do run into situations where both motions or responses can be surprises to both the parties and the court, and these are dispositive important motions. There needs to be time in order to consider the authority, the case law, all of those things. The way that we proposed it in our rule was it's attached to our comment, is an earlier of 40 days before the motion or a deadline in the case management conference. That provides the courts an opportunity to be flexible in how they prefer it if they want to include it in their case management order. And as to the response, at least 60 days, the later of 60 days or 10 days before the hearing. That way it still works as a backstop to the concerns that were brought up earlier about summary judgment motions that are not responded to hanging out there and being a case management issue, but it also gives flexibility and time for people to review things before the hearing. Thank you.
Okay, thanks so much. We appreciate it.
Good morning, Your Honors. May it please the Court. My name is Kevin Rabin. I'm with the Florida Housing Umbrella Group. We made a narrow comment regarding proposed Rule 1.202. Much of what we would like to say has already been taken up, so I'll keep this short and brief. Most of our members practice in county court and eviction and summary procedure actions. We wanted to make sure that the court was aware of the impacts that this rule may have on summary procedure. There's two specific pieces of the puzzle we would want the court to keep in mind. The Florida Residential Landlord and Tenant Act imposes upon tenants this requirement to either deposit rent or file a motion to determine rent. Imposing this kind of conferral requirement to file that motion, especially for many self-represented tenants, will serve as a barrier to deter them from accessing the courts. It's required by statute in order to avoid a default judgment against them for possession, and so since they're often trying to file this as quickly as they can, especially in a procedure they don't understand very well, imposing this additional conferral requirement to call an attorney that represents the plaintiff landlord, it's a struggle, and it's going to lead to a lot more tenants that are going to be potentially evicted simply because they didn't understand this requirement to confer. This also would apply to unlawful detainer actions. Again, this is an area in which summary procedure applies. And a lot of the court's admirable case management goals that the motion conferral rule is ultimately meant to help address, to reduce the amount of litigious motion practice. We don't think that that would necessarily make much sense in a summary procedure case to begin with. Most of those cases will go from initiation to case disposition in about 2 months, and we assume that this would be a good exemption to make sure that that rule would not apply to the summary procedure actions. We would also point to the court, we really appreciate the recent creation of Form 1.947 subsection B, the eviction
answer form. That also included a checkbox for a motion to determine rent, but that form doesn't currently include a motion conferral statement. We would obviously point out that that would be a bit of a concern. We know that a lot of the clerk's offices were very grateful to receive that form to provide self-represented litigants, and we would just make sure that if the court does use its current rule, that it makes sure that the form is updated as well to include that certification. We appreciate the court's attention to conferral. We agree that conferral with opposing counsel is often a great way to resolve any type of disputed motion. However, we would also recommend the court, to Justice Labarga's point, start with a more narrow focus, trying to address some of the most contentious types of discovery motions at first, and then begin to broaden out from that perspective. The Civil Rules Committee's proposal is very good. We like the exemptions. There's also a lot of them. And so we would suggest, rather than starting with a list that has so many exemptions it could swallow the rule start more narrowly and expand from there.
Okay, thank you so much. We appreciate it. Okay, our next case is in re amendments to Florida Rules of Civil Procedure, and it's case number 2023-0962. Mr. Edwards. So now we get to the easy stuff.
Mr. Chief Justice, may it please the court. Tom Edwards, and I'm here individually. I'm a prior member of the work group and now a member of the Rules of Civil Procedure. I raised concerns in my comment about the need for enforcement mechanisms which were not included in the original versions of the discovery changes to the discovery rules. Most of those are now remedied with the new proposed 1.380, but not 100% of them. And we have now incorporated into 1.380 some of the additional provisions from the federal rules that would mimic what is in Rule 37. The one outstanding issue relates to Rule 1.280, and it is the certification sanctions if a lawyer is certifying discovery with their signature and have done some things improper, either the party or the lawyer. And that is actually underway with the committee, and it has already been voted on once, and I've conferred with the chair, and that can be expedited. He'll be speaking at that in just a few moments. So it is on the cusp of being passed, and that would address all of the substantive concerns that I raised on the need for rule changes. There are a couple of additional issues. Number one, I do think it's very important to have these enforcement mechanisms. I am not a fan of sanctions. I don't think lawyers should be sanctioned for doing their jobs and advocating things appropriately, particularly on close questions. But there are instances where sanctions are needed when people are not providing discovery as they're expected to under our rules. At page 18 of my comment, I gave case law that dates back to 1947 from the U.S. Supreme Court and multiple cases from this court that explains why the open and proper exchange of discovery is essential to the efficient progress of cases through our court system, and it helps the efficiency of cases resolving when they should if it can be done earlier in the process. So these enforcement mechanisms that are now in the works are really important. The one other issue that I was going to touch on is somewhat controversial, and that is the advisory notes from the federal rules as it relates to discovery when we're now changing the basis for discovery in our rules and some of the enforcement mechanisms. Traditionally, our Rules of Civil Procedure Committee opposes having comments and advisory notes because they are not the law. The law is set by the court and the rules. But as we're embarking on this, and we're embarking on new sanctions rules and new rules for what can be discovered and proportionality, it's important for lawyers and judges as quickly as possible to be able to get up to speed on what their obligations are and what the standards are. The advisory notes that are in the federal rules, and they are in some instances extensive. I think the notes for Rule 26 span 34 or 36 pages, and they're single-spaced, they're dense, but they're also very helpful in giving guidance to judges and lawyers. And I gave examples of this in my comment. At page 14, I give an example of a very important change in the rule that omits language that used to be in the rule, Rule 26, that we're now adopting. And the reason it was omitted is not because these things are no longer discoverable. The example I give at page 14 of my comment explains that this is now so embedded in the law, we don't need to have instruction in the rule anymore that this stuff must be provided, but it's still stuff that is supposed to be provided because there's lots and lots of case law that says that in the federal system. And so that, if you look at the example that I'm giving, it's only one example of many other instructive devices that are in the advisory notes that will be helpful to lawyers and judges in doing things properly and efficiently in our system. I think I also give an example at page 12 of my comment where when you passed the summary judgment rule recently, you added a comment that referenced some of the federal law. You can do the same type of thing as it relates to the changes in Rule 26 and the changes to Rule, or not 26, 1.280, and the changes to Rule 1.380, so that lawyers in our state have that as advice and judges in our state have that as advice to help them understand what their obligations are. And it can be made clear in the comment that that's not the law, but it is there as an assistive device. Those are, I've really covered the issues that I think I needed to cover based on my comment. I do want to tell you that I know in the past there have been times when the court perhaps felt the rules of civil procedure was not moving things efficiently and as quickly as perhaps the court needed. I can tell you that with these rules, they have been bending over backwards. I've been a participant with them in it, and we have had meeting after meeting, some going into the evenings to get all this done and get it done efficiently. And I know that our leadership has really stressed getting things done timely and efficiently. And the conversation I had this morning is that we can get this done with this one additional piece that's still outstanding on Rule 1.280.
I have just one comment, one question,
yes,
and I appreciate the work that the committee has done, and I appreciate the court's involvement in creating a rule, in creating the structure. In the way litigation takes place and in today's legal world. One thing that you mentioned in your comment that struck me on the issue of proportionality, and to be expected, I believe, if my experience tells me that we're going to get a lot of boilerplate objections, objection proportionality. You'll get that kind of thing. And you suggest that the only way to stop that is sanctions. And you mentioned that we have pretty much covered the sanctions in the rule already, but I think you suggest that there should be a specific sanction in a proportionality rule for such type of behavior where they're going to make just an objection to that. Because, I mean, if you think about it, if our purpose is to move things along, well, I see in proportionality a big black hole where that objection is made, and I'm trying to figure out how does a judge handle it. When you come before me and there's a proportionality objection, how do I decide whether it is basically, you're asking for too much for this little case, slip and fall case, and now you want, the financial records of the corporation. I mean, how do I decide, as a trial judge, how do I decide whether something is not proportional to the case?
It's going to require digging into the advisory notes and the existing federal case law if you all are going to do something similar to what you did in the summary judgment rule and recommend that the judges look at the federal case law on these issues. The federal judges have been pretty conservative in applying the proportionality rule. And there are devices, including the note that I referenced from page 14 of my comment, that recommends methodologies for dealing with some of those issues, such as now in electronic discovery, which we're confronting more and more and more. We now have electronic medical records and audit trails and things of that nature. What the particular comment I referenced, even though the language has been taken out of the rule, recommends that there should be initial discovery on what is the audit trail mechanism that's used. Give us the list of all the audit trail materials that are available. Give us initial information about what is there, so that both the judge and the opposing attorney can now look at how we narrow it and what is legitimately related to the case.
In federal court, the judge will deal with that back in his office and issue an order. Now, in trial court, my concern is it going to require a hearing?
Actually, and that is, and I don't want to blow by it, I did touch on this. I did not reiterate the concerns that were expressed previously in the prior oral argument and in the work group's report. I do continue to have concerns that our courts don't have the resources to deal with some of the problems that will be coming dealing with discovery. In federal court, the district court judge has 2 or 3 law clerks, and there is a magistrate. Typically, when a federal court discovery dispute occurs, it's referred immediately to the magistrate, and the magistrate is dealing with it within a month. And as soon as the briefing's done, you're called in and it's dealt with. In state court, it takes 3 to 6 months, depending on what judge you're in front of, to get a hearing on these kinds of things. And that is going to play havoc with the trial order when it impacts stuff that's necessary for depositions and presentation at trial.
And these proportionality objections, they can come up in the middle of a deposition.
I suspect we're going to be seeing the same kinds of things we see a lot of times now with interrogatories and requests for production, and that is standardized objections and proportionality. It's going to be listed in there. And I just had this happen to me within the last 2 to 3 weeks. They listed a string of standardized objections in a federal court case, listed proportionality with no explanation of what the proportionality objection was. I then respond, and in federal court, they file their objections. I have to then file my motion to compel. They give me no information on what the proportionality objection is and what it's based on, and they then respond to it and attach a declaration from their client. And in federal court, I now don't have the right to a reply. I'm now going to have to ask for a reply now to deal with proportionality for the first time, knowing what their real objection is. And that's what I fear we're going to be seeing in the near future with this kind of stuff.
So in state court, instead of all the back and forth pleadings, you would just schedule for a hearing?
You'd have to, and if it's happening like frequently happens now, you're going to get a long list of objections with no true explanation of what the substantive basis for it is. With a proportionality objection, there should be a basis provided with it at the time of the objection, but that rarely happens.
So what happens to your case as far as moving along to get into trial? If you get caught up in one of these proportionality many objections in the middle of litigation.
If you're not getting the documents that are necessary then to move forward with your depositions, it's going to impact all the deadlines.
There you go.
So, I am happy to answer questions if there are any further, but that really covered. I do want to add one thing. Judge Moe and I discussed one issue related to the continuance rule right before this started that I think she's going to touch on, and I am supportive of it and have seen some of the same problems I think she's going to discuss.
Thanks a lot. We appreciate it.
Thank you.
Cosme Caballero on behalf of the committee. I want to quickly touch on an issue Mr. Edwards mentioned about 1.20K. It is true we are moving quicker these days, and just as a housekeeping matter, the committee has voted to eliminate the 2-vote requirement so that we can move things a little bit faster. And that's all working in progress, but it has its procedure. With regard to 1.20K, I would mention what Mr. Edwards has suggested. And the current rule, by the way, 1.20K, as drafted by the court within its opinion, basically has all of Federal Rule 26G. It's just missing certain components, should look like, and it basically takes the language from 26G, and it applies the right cross-references. It has everything correct for the rule, and so we could make that happen very quickly. With respect to the advisory committee notes, I know it's well-intentioned, but that really has no place in our rule set. Can you have a comment like you do in the federal, in the 1.510 that references says, look, we're adopting the federal summary judgment standard. You can look at the case law dealing with that particular standard. Sure. I would say try not to add language into the comments because different judges look at those comments and committee notes differently. They look at, some of them see it as binding, some of them don't see it as binding. I would mention that the advisory committee notes from the federal system, they are useful, they do provide guidance, but Rule 26G, you're talking about committee notes that span from 1970, amendments spanning from 1970 to recently. You're talking about 10,000 to 20,000 words of content. They get used for guidance anyway within our system. Everybody knows our rules are modeled on the federal rules. Judges every day deal with arguments based on advisory committee notes. I would urge the court not to adopt and transfer committee notes from Rule 26 into our 1.280. It's ultimately going to cause more problems and more confusion. You also have the issue of if you have those notes in 26 from 26 and 1.280, but you don't have it in other rules, are the advisory committee notes for other rules somehow not have any effect? So I think it's not a good idea. The committee generally does not view that as a good idea. I want to transition to proportionality. I really don't have anything philosophical to say about it. I just want to talk about what tools we think will help implement it. Mr. Edwards is right. Proportionality in the federal system, for anybody that's been involved in it, it generally encompasses discovery disputes involving tremendous amounts of data, tremendous amounts of information. You're talking proportionality comes up in multi-district litigation. It comes up in very significant disputes. As written, it will apply to small cases. It will apply to cases that maybe this shouldn't be an issue, but it's going to be an issue. So what we want to do is create, as a committee, is create tools that help facilitate that process. Specifically, we provided the court, we filed it as a separate report to the court. It was case, I think, 2024-1385. The court recharacterized it as a response to comment in this court. And what we proposed were to bring into Rule 1.340, the interrogatory rule, bring into 1.350, the request to produce rule, the language from the corresponding federal rules, 33 and 34, that requires specificity with objections. We don't have the analog right now in our rules. I would urge the court to adopt those. We also implemented into an amended, or proposing an amendment to 1.350 that requires when a responding party is going to withhold documents based on an objection, they have to say they're doing that, as opposed to just keeping everybody sort of in a limbo state. This will provide transparency. It'll facilitate the conferral process. Greater transparency in the objections is better for conferral. I would urge the court that if you do adopt those, and we would strongly recommend you do, it was unanimous with the committee. We have a judicial input subcommittee that I appointed, 17 judges from each circuit, from the 20 circuits. We're missing 3. Hopefully we can get some folks to join in. But it was unanimous with those folks. Everybody wants this. I would urge the court, if you do adopt it, put in your opinion strong language that generalized boilerplate objections are not sufficient. They're not what should be done. I think that would help the process. With respect to 1.380, we also brought in from Rule 37 the provisions dealing with what happens when somebody doesn't comply with the initial disclosure obligation, what happens when somebody doesn't supplement discovery, which are now part of what 1.280 has. That needs to be there. Honestly, I think what happened in the process of drafting all this, the 1.380, 1.340, 1.350 were not part of the court's referral. They were kind of outside the scope of what the committee was looking at and may have just kind of fallen outside the loop. We went back, looked at it, realized based on a lot of the commenters and folks looking at this that it is appropriate to add those provisions, and I think they work to hand in hand with these obligations that the court's imposing with initial disclosures and supplementation. So we would urge the court to adopt those changes that the committee is proposing, specifically the ones from our report in 2024-1385, which are now part of this case. And then I would urge the court, as Ms. Luca mentioned, 1.30 has a conferral requirement, as everybody knows, within the motion to compel section of that rule. Now that's not going to be so. That conferral requirement should be eliminated in favor of just leaving the one conferral requirement from 1.202 so you don't have inconsistency. The same is true for the 1.460 continuance rule. That has a conferral component. I just mentioned that now. I know it's outside the scope of this, but that needs to be eliminated too so that there's consistency. Thank you.
Thanks, and we really appreciate all the work the committee's been doing. We know that we've been generating a lot of work for you guys on top of everything else that you're doing, and we really appreciate the spirit of cooperation and the thoughtfulness of the comments and everything.
Yeah,
so
you're
thank
welcome.
you very
We're
much.
here to serve, so whatever we can do, we'll do it.
May it please the court. I have just a couple quick thoughts on multiple provisions. I'll go in order of the rules. 1.200D3 and E1 have a theoretical conflict. I feel very strongly that the way to resolve it is to delete 1.200D3 in favor of just having E1, which says deadlines in a case management order must be strictly enforced unless changed by court order. I think that is the most succinct and direct way to state the necessary principle. Regarding 1.200D2 and 1.200B, I think a comment filed by David Caldevilla, Braxton Gillum, and Kenneth Scher has a very good point, which is that 1.200B says that a court has 120 days after a complaint is assigned to assign a case track. But 1.200D2 says that a court has to issue a case management order, which has to include the assignment, within 120 days of filing or 30 days of service, whichever is earlier. So B says you have to assign the track within 120 days, but D2 says you have to issue a case management order theoretically within 30 days, but you can't do that unless you've assigned the track. So basically you have more time to assign a track than you do to issue a case management order, but the case management order has to include the assignment of track. They're inconsistent. I think Mr. Caldevilla's suggestion is not my suggestion. Mine is that the realistic thing to do is to make it 120 days from filing, because I don't see a universe in which judges have the capacity to babysit their dockets to look for a notice of service. They don't know when 30 days has passed since service. Just make it 120 days from filing. And also, there are Hillsborough, Miami-Dade, other circuits are working on having automated procedures. So let's strive for realism. Mr. Scher and Mr. Caldevilla also had a very good point, I believe, that the case management rule requirements for extending a deadline could be read to conflict with 1.090B. 1.090B is the one where I say, Your Honor, I have a very heavy trial load and I need 10 extra days to respond to a motion for summary judgment. The case management extension rule is where you have to explain what the date is that you need to have moved, what you're going to do to make it happen. You know, my expert got sick, therefore we need the deadline for expert disclosures extended. We have confirmed that he is available on X date. Opposing counsel does not oppose this motion. There were very specific requirements. To ensure that there is no conflict and that there is no confusion, I would propose that you create in 1.090B, that you create a section 3, have it say applicability. This rule does not apply to moving deadlines in a case management order. The proper procedure for extending such deadlines is contained in Rule 1.200E. Ta-da! It's very clear. I also agree with Mr. Caldevilla that, and this was at page 10 to 11 of his comment, that judges should be able to hear a motion for summary judgment at a case management conference if there is time and both parties stipulate. That is the key. When the summary judgment, when the committee created the rule that said that if you want a case management conference, the price of admission is that you have to give the judge a list of all of the pending motions. Even if that's not why you're there for the case management conference, it's a case management tool for the judge, so they could look at it and say, okay, this case is 120 days old. Why is there a motion to dismiss that's still pending? Let's get that heard. And the rule says that if there is time, that the judge can order the parties to come to the case management prepared to argue it. You have to give the parties notice, due process. But we said that evidentiary hearings and summary judgment hearings or summary judgment motions could not be ruled on at a case management conference because those tend to be more involved. I see Mr. Caldevilla's point, which is if the parties really want the court to rule on it and both parties agree and there's time, then the judge should be able to. So I suggest that you consider making that change. In 1.201, which is the complex case rule, I think that you need to reorder. I think you need to have complex litigation defined as your letter A. And then I think you need to change letter B so that it is moving to designate a case as complex. It's way too complicated to try to explain to you in words. It's in my comment at page 11. That is where my, actually, it's at page 10 of my comment is where that section starts, and I would really strongly encourage you to consider that. 1.280K is something that I caught the typographical error in my comment, but my comment actually had an error, so I'm flagging it. Please, this is important. The Civil Rules Committee, after I filed my comment, we met, we saw it, we agreed that this is something that needs to be changed. You'll be getting that in a filing after it gets approval from the board, but what it needs to say is that every disclosure, not just discovery disclosure, every disclosure under subdivision A needs to be supplemented. That's on page 16 of my comment.
What is that? What is that rule again? The subdivision.
1.280K.
Thank you, Justice Corio. On proportionality, I would ask that if you are going to adopt it, that you, I have no idea how the sausage gets made on this one, who looks at your Florida Supreme Court standard interrogatories, but these rules apply to county court cases. And if in county court you've got somebody who had a slip and fall and they're looking for $10,000 to cover their medical bills, I would point you to two examples. Florida Standard Interrogatory number 16 is list the name and address of every physician, medical facility, or healthcare provider who you've seen in the last 10 years and state your dates of examination and treatment and the condition for which you were examined. In that case, if we're going to have proportionality, that's not going to be proportionate, but because it's a Florida Standard Interrogatory, then it's pretty much rubber stamped that you need to be answering it. So food for thought that perhaps you want to re-examine or somehow soften whether those are standard for all cases. I also want to address a comment by Judge Huey regarding 1.280. I agree with him that we need to add the word economic as a qualifier in Rule 1.280. Are you ready? A1C. I think that's a medication. It says that the parties have to disclose a computation for each category of economic damages claimed by the disclosing party. His point is, please just make my life easier, put the word economic there so I don't have people coming in and arguing that they have to do non-economic too, because there's just no way to quantify in an initial disclosure what non-economic damages are. Judge Huey also asked that expert opinions have to be supplemented within 10 days of the expert providing the opinion. I would recommend against that because state court isn't like federal court where you have to submit a report. It'll turn into a game about when your expert gave you the opinion. I understand where Judge Huey's coming from. He's trying to move the process along, but I don't I don't see that one being beneficial. Judge Huey also asked that all videos and photos taken by a party or agent at the accident or incident scene, regardless of when they were taken or by whom they were taken, be required to be disclosed. And the input that I would provide on that is that if I hire a consulting expert and I ask the consulting expert to go to the scene, the consulting expert is my agent, but anything that the consulting expert does is privileged. So under Judge Huey's proposal, I would have to turn over privileged information. So I don't recommend adopting that particular one. Again, I understand where he's coming from, but I think the way that he proposed it would work a lot of mischief, and it would actually wind up in some instances being contrary to the law. I agree with Mr. Edwards that it's useful for people to know, and I think to address Mr. Caballero's concern, perhaps the court could add a comment to Rule 1.280 that says something to the effect of, when this court adopts a federal rule, it intends to adopt the federal committee notes and case law and body of case law that accompany the rule. Short, simple, and I believe that's exactly why you ask to use the federal rules. Deborah Ingraham made a suggestion of requiring a HIPAA release for every healthcare provider as part of the initial disclosures. If you listed a healthcare provider in response to an interrogatory, she wanted a HIPAA release to be required to be provided. I would point you to the interrogatory that I just read to you. If every DCA in this state says that when it comes to medical records, if it's not relevant to the case at hand, it is protected by Florida's constitutional right to privacy. If I have to tell you every doctor I've seen in the last 10 years, and those doctors have nothing to do with my injury in this case, you should not be allowed to have a HIPAA waiver that would get you those medical records. So I understand her goal, but I do not think that it is a good idea. I reserved 3 minutes, and as usual, I went too long. I promise I've got 2 points, and I'll just hit one. I'll do the other one in rebuttal. CJE. On Rule 1.460, I know Judge Moe is going to talk to you about this, and I am so grateful for it because you can hear it from a judge in the trenches. I am worried about discretionary jurisprudence because I have personally appeared in front of multiple judges, and I have heard trial lawyers tell me that they are appearing in front of judges who are saying, the Supreme Court says I can't grant a continuance. And to that, I want to scream, no. I chaired the committee that wrote that rule. That is not what that rule says, and that is not what the Supreme Court is saying. I would strongly encourage you to, much like you did with the ethics rule for attorneys, create a mandatory CJE. And Justice Labarga, if you're still in charge of CJE,
no more.
Not your circus, not your monkeys.
No more.
I don't know who's doing it, but whichever one, make that one available via Zoom. Make it something that they have to take within a certain number of days of the case, of the rule becoming active. Make it, if we're going to potentially move the active date, make it something they have to do beforehand. But please have it taught by DCA judges who are former trial judges, because they will be the ones interpreting what the judges do when they are appealed, and having served as a trial judge themselves, they can empathize with what that feels like. But I think that you want to have a mandatory CJE so that the judges who think that you're saying that you can't grant a continuance know that what you're really saying is, if you're lazy and you haven't touched your case in 18 months, you don't get a continuance. If there is some reason that your case can't get to trial and you've been working diligently, then that's a different scenario, and the judges need to exercise their discretion in that scenario. And I will save any time you're willing to give me for rebuttal.
Okay.
Thank you.
Thank you. I appreciate it.
Any thought I had about practicing law in my afterlife has been extinguished today.
May it please the court, Ann Lee Moe from Tampa. It's a pleasure to be here. I think that perfect is the enemy of done on some of these rules. And I think that if there was ever a day in which a bond validation case would seem exciting and easy to understand, then I think we have provided that for you, and they can thank us later. But ultimately, I agree with what Ms. Luca said. We all know that this court has promulgated Rule 1.010 not a rule before the court, but that rule says that all of the rules are intended to be construed to affect a just, speedy, and inexpensive result in a case. We know that. We appreciate that. I think some of the comments almost assume that we wouldn't do that, and I think that for that reason, some of the comments maybe are valid concerns but are overblown and are not remembering that we have common sense. So I wanted to talk briefly about 1.510. Thank you for doing that rule. That I think will be a tremendously helpful thing. I agree with the idea that 60 days is more generous than is absolutely necessary. For trial courts, if you were looking at something other than 60, and if you were willing to consider that, what I would propose that it would be 20 and 10. And there are two reasons for that. One of the reasons is if I were to ask you to calculate a deadline without, in the next 5 seconds, and the deadline is 30 days from today, I think you could probably hit the nail pretty quickly. But if you add 10 days to that, if what is 40 days from today, everybody's going to have to get out their phone. So I think it'd be easier for JAs and for judges and for lawyers and for everyone to know when they can set that daggum hearing if they understand that it's 30 days instead of 40. It may seem like a small thing, but all you have to do is give yourself a series of dates and then try to off the cuff think of what's 40 days, and it's just harder. So the 20 days would allow them to have time for that response. There is no number of days that you can come up with that you're not going to have the result of someone saying, I don't have enough time. So that you can take that off the table as your matter of concern, because you already have a rule that says if you think that if the motion was prematurely filed, you have a mechanism already in the rule, and that will definitely be invoked, and it may be invoked even more now. But the reality is it's going to be invoked one way or the other. You have a good rule. You have a good procedure. 20 days should be enough. And ultimately, if at the trial court level, if we do not get committed to the idea of sequencing and spacing deadlines throughout the course of the case, then a lot of this, we're just destined for frustration and inefficiency if we don't get committed to that idea. But I think this court knows that already. I think that there's probably in the works already the idea of having a CJA for judges to talk about sequencing and spacing and case management orders. And I think that over time, even if you don't do that, we all have common sense, and we all benefit from the experience of what it feels like to have to do case management where you don't sequence and space, and it's an exercise in frustration for everybody. So
What's your opinion? I'm sorry to interrupt you. What's your opinion on the tolling suggestion that Ms. Luca had?
My opinion on the tolling suggestion is that it's probably not necessary, again, because we have the ability as human beings to exercise common sense. And if someone comes in and they say this motion for summary judgment was filed 30 days after the case was filed, instinctively the judge is going to know that there's a decent chance in that situation that it's prematurely filed. And on what planet is someone going to say, I know you filed that and you needed to get the deposition and you never got it, and I agreed with you that you should have it, but yet we're going to move forward on that hearing. I just don't think that that's likely to happen.
I think her thing was on the response time, no.
The tolling of a response time?
Yeah.
Well, I think that in practical effect, the way last week, by the way, one of the benefits of the conferral rule is that now my hearing time is spent. I had a day last week where I spent all day long in summary judgment hearings. That's because I do not have to have nearly as many hearings on all the things that Justice Lavarga, when you were at the trial court level, this conferral rule has changed our lives. But the reality is when someone files that motion seeking additional time, frequently that will mean that the opponent will say, okay, I get it, you've made a good point, you say you need that, I'm going to go ahead and have that deposition so that we reschedule that hearing. They file the motion saying, I need more time, the summary judgment hearing can't go forward. It's the person who benefits from not having the summary judgment granted. And the reality is that you can just get out your case management order. They say they need more time for fact discovery. Well, fact discovery closed 6 months ago. So the answer is that motion's denied. Let's talk about summary judgment. So there is an interplay between all of these rules that I think this court well understands, and I think that the trial courts are really well on the way to understanding that I agree that judicial education will be more helpful, that should always be on the table, but I don't necessarily know. The problem with I think the problem with any idea that there is a mechanism by which you can stop the train from moving simply by filing a motion introduces just as many problems as it solves. So with 1.460, you've got a preview that I wanted to talk to you about that. That's a beautifully written rule. It's a great rule. The objectives of the rule are very good, are very laudable. There are two things. Number one, I agree that there is a widespread perception that the amendments to Rule 1.460 mean that trial courts no longer have the discretion to continue a case that should be continued. That's a real problem. When you hear someone say that, I want you to know from me that I see exactly the same thing, I hear exactly the same thing, and I think that that is a very real concern, particularly when we consider Rule 1.010 and the need for our rules to be construed to be a just being the first one, just, speedy, and inexpensive. I do not know exactly how this court will go about remedying that. I think judicial education is important, but I suspect that the origin story of the reason why judges have that perception is that when the administrative order came out about differentiated case management, that was a necessary, wonderful shock to the system. We then had the oral argument about the entirety of the work group's proposal sometime later. Before that oral argument, there was a very comprehensive, broad effort to educate lawyers and judges that there was this work group proposal out there, that this court wanted everyone's feedback. And as part of that education effort, I think that there was discussion about a different continuance policy than this court has actually adopted. And I think it's the residual of that has caused there to be a misperception that you are saying, or that this court is saying, that we cannot ever grant a continuance. And
the text of the rule doesn't say that.
It doesn't. You're absolutely
right. At some point, people have to read.
I 100% agree with you, Justice Kennedy. I couldn't agree with you more, but I will say this. The reason why I'm concerned, you are absolutely right. You cannot, if people are not diligent enough to read a rule, then there's no fix for that, except, hopefully we can get them when they're in kindergarten and teach them to read sooner. But ultimately, the problem we have is a very practical one. In March of 2023, in response or in anticipation of a tort reform bill that was passed here in Tallahassee, there was a surge of filings across the state. As a result, for example, in the 13th Circuit, the circuit civil docket in Tampa was doubled in a 10-day period. For circuits that took docket control measures in response to that, that has not ended up being that big of a problem. But if no docket control mechanisms were taken and put in place, what that means is that all of those cases matured in September of 2024. And the effect of that, coupled with this idea that cases cannot be continued, is that we have, if you were to ask, I think, any of the lawyers who have a personal injury practice, because those are the ones that were affected, ask any one of them what is happening to you, and you will find invariably that there are lawyers who are next week set on 23 trial dockets across the state. And in those 23 trial dockets, they are hearing from the judges, and a certain percentage of them, I will not continue your case because the Supreme Court says I can't continue your case. They then show up on Monday morning to try the case, and of course the judge has 50 cases that are set for trial because they're all the ones that matured from March of 2023. The judge can't try all those cases, and so then those get rolled to next month. All but the one that got tried this month gets rolled. That is catastrophic. And I think that...
Why is it... Help me understand why it's not in the judge's self-interest to avoid that catastrophe by actually opening the book and reading the rule and then granting some continuances. I'm not understanding why that catastrophe isn't... It's in everyone's self-interest to avoid it, so why is it not being avoided?
I cannot answer that question, Justice Coriel. What I can tell you is that whatever the reasons for it are, the experience that is occurring is what I've described. And so, again, to your point, Justice Kennedy, we should all be reading. I mean, there's never a substitute for actually reading what law we're supposed to follow. And I don't mean to suggest that anyone is not reading or not capable of reading, but the other aspect of this is that while I don't think that there should be this pervasive concern that trial judges can't handle their life, because I think that we all can buck up and do what we need to do. But the reality is the same dynamic that is so difficult for the lawyers is very difficult for trial judges right now. And so to say, while under normal circumstances you could say, well, a change in the rule, just get out the rule book, dadgummit. But the reality is that those judges are also absolutely struggling with the fact that all the cases that were filed in March 2023 matured at exactly the same pace. And so what that means for all of us is that even like Tampa, we're not we can handle it, but the reality is we get more requests to amend a case management order because they're not all set for trial with us at the same time, but they're set for trial everywhere else, and they can't get to our stuff for discovery. So we are just, what I wanted to communicate to you is we are just in a situation that I think is a different environment than was contemplated at the time that this rule was first floated. I think that the fix for that is judicial education, obviously, but then secondarily, potentially the idea of delaying the effective date of 1.460, or simply having an all-hands-on-deck meeting to explain this is a rule that everyone needs to really understand. It's pretty important. There may be a misperception.
I think we'll go with Plan B.
So with two very small things, but I think that are not small in practical effect. 1.200D, 2, F, and G. There is reference to two deadlines that are currently phrased as the deadline to resolve. Their deadline to resolve objections to pleadings, or the deadline to resolve all pretrial motions. A deadline to resolve is a deadline for the judge. That's what the 13th Circuit interprets, that's our deadline to rule. But we rule on things when someone sets them for hearing. So that may be a difficult rule for us to enforce. If that were tweaked to say that the deadline is for the deadline to file objections to pleadings and to file pretrial motions, that's easier to resolve, easier to actually enforce, provides a meaningful cutoff for things that we need to cut off, but also if there's potential for ambiguity, if the court agrees that there's some room for everyone to be confused about what does the word resolution mean, and is that the same thing as filing, or is it the same thing as deciding, the impact and the import of that is that there is about a 60 to 90 day swing in when that deadline should fall logically. A deadline to file should obviously fall sooner than the deadline to resolve.
Which rule was that?
That was 1.200D2, subsections F and G both have the same thing. And I think that with regard to objections to pleadings, that in the 13th Circuit we actually had a much longer debate than you would ever imagine about what is an objection to pleading. And I think that what that means is a motion to dismiss or a motion to strike. If what was intended was motions directed to pleadings, if that's what objections to pleading is intended to say, I think that it would be worth considering whether or not just to say motions directed to pleadings instead of objections to pleadings. I thank you so much for your time, and I appreciate your patience. Thank you.
Thank you. We appreciate your comments.
May it please the court, the business law section filed a very short, narrow motion just supporting the inclusion of proportionality in the modified scope of discovery, and I'm here to answer any questions if necessary, but I'll just very briefly touch on a couple things that are helping with the efficient resolution of these cases. We all have trepidation about change, and I think that's part of the concern about proportionality, but the federal courts have been applying this pretty successfully for 10 years, and there's a great body of case law about that the Florida practitioners, I'm sure, will be able to read and can use for the courts to make these decisions. This is just a tool to resolve the disputes that are already happening. And the benefit of having this here is the practitioners, when drafting their discovery requests, have to do so with proportionality in mind, and that will help reduce some of the disputes because you're working on it on the front end, not the back end. Again, this is the method for how these are being decided will stay the same, but Justice Labarga, if there's a boilerplate objection, the sanction for that is it's most likely going to get denied as being unsupported. So if along those lines, as this Rules Committee has proposed and the section has reviewed and agrees with the proposed changes requiring specificity in 1.340 and 1.350, we support those and think that will help also reduce the occurrence of boilerplate objections. So with that, unless there are any questions, we support that inclusion and we appreciate the court for your time.
Thank you very much.
Good morning, Your Honors.
Morning.
My name is Karen Giebers, and today is the 46th anniversary of my becoming an attorney.
Great.
I can't believe the time went so quickly, and thank you for letting me mention that. I'm here this morning on behalf of the Florida Justice Association, essentially the plaintiff's bar. Our members have cases in all 67 of Florida's counties and all 20 of the circuits. And I've also had the extreme privilege to serve as a circuit judge here in the Second Judicial Circuit for a little over 8 years, from 2011 until I aged out in April of 2019. I served in all of the different divisions during the time I was on the bench and saw from the judicial trenches how life differs for our trial judges in a rural city or county versus a big city, and the expectations we have, because generally people on the trial bench don't come from a singular background. We have folks who were state attorneys, folks that were public defenders, people that did family law, maybe dependency, that's generally very rare, some circuit civil, but all backgrounds. And very few of those backgrounds included anything to do with the federal practice. So familiarity with federal rules, case law, et cetera, is something that is not part of the normal acquired knowledge to that point. Even in a small county like Jefferson, there could be an event such as where a tourist gets murdered at a rest stop on I-10 that becomes all-consuming, and there's only one circuit judge assigned as a part-time assignment to handle every division at the circuit court level in Jefferson County. That judge does not have time on his or her hands to be looking at proposed civil procedure rule changes that will affect the circuit civil cases in that county. Everything is the responsibility of that judge, and when you have a high-profile event, then everything suffers. Another thing that our trial judges do not have is a single law clerk lawyer dedicated to them. Each circuit has some, usually 4 or 5, that handle unusual cases or habeas corpus issues or prisoner petitions, but no circuit judge that's in a circuit civil division that I have found has their own dedicated law clerk. And the concerns that the Florida Justice Association has, there are some members, of course, who would prefer not to add the proportionality rule in there, as the comment mentioned. But if we're going to bring in a federal concept, then we should have the resources that the federal system has so that we are not overburdening our already overburdened, whether due to COVID or legislative action or whatever. Our circuit judges work hard trying to do the jobs they are to do, and they often involve more than one assignment in one division. I know that those judges that get assigned to a division like dependency, where they may not have had experience, they get a system-prepared bench book. It lays it all out. Easy reading, helps them understand what they're supposed to be doing as they handle that social work division and help try to get families reunified or terminate parental rights and get children adopted. Each division has different rules. You all are just amazing to be able to handle all the different rules and make sure everything flows seamlessly, which is the hope. But from the standpoint of the Florida Justice Association members and the others who have spoken, all of us have one thing in common, which is we want our trial judges that are handling circuit civil cases to be able to give them the time and the attention that they need. And that includes thinking time. It doesn't include it should include time to read every memorandum of law that's submitted on a motion to compel or something, and then read the response and have a law clerk or somehow time to see if anyone miscited cases, or God help us if we get into artificial intelligence and we find out the artificial intelligence is manufacturing cases that don't exist, as happened in an incident that has been widely reported on in some of the attorney seminars. We have to be vigilant. We have to provide justice to the litigants in front of us. Everyone needs to be treated fairly. And so I don't know how you put the extra burden of the discovery and the motion practice that will inevitably follow the proportionality if there aren't two things that happen. Number one, there needs to be a proactive education outreach to the trial judges that are going to be responsible for handling this, so that on whatever day the new rules become effective, they know that, as you did with the summary judgment rule when you switched to the federal standard in 2021, that you're switching to the federal standard, which cases they should look at. If you're not comfortable adopting the federal advisory notes or committee notes, at least prepare a bench book, because those trial judges that are in the courtrooms right now or having their assistants try to find hearing time for somebody to have something heard, they don't have time to be looking at all the case law that interpreted the federal rules and advisory notes. There's just not that time, and they don't have, unlike the magistrates, they don't have magistrates. The federal magistrates have law clerks. Anyhow, you get the point. There is no reason that we cannot all work together. If we're trying to become more like a federal system, we can work together to get the legislature to fund a federal-type system. But if you're going to overload the judges, then none of the parties that are going to be practicing in front of them, everybody trying to comply with these new rules, will be in a position to meet your time standards. So the second thing, resources. First, the other thing is sanctions, because without sanctions and a means of enforcement, whether it's an admission of a fact or monetary sanctions on a party or lawyers, people have to see that you think the rules have meaning. There's a game that many of us play as children called telephone, where you line a bunch of children up and you whisper something to the first person and they pass it down the line. And by the time the last person hears it, it has no relationship to what was intended and what was said at the beginning. I think in a way, the panic that was referred to regarding the judges can't grant continuances anymore comes from people that don't have time to read and think about the rule change, and they don't understand what good cause means, and there's just no time for anything, it seems like, because we have gotten more remote from each other, first because of COVID. We do save a lot of time not having to drive from one end of the state to another for a half-an-hour hearing. That is a big help, not being on the road all that time. But it means
more time you would think to read the rules.
Well, there's that too, and I don't know how, I haven't seen criteria for folks to pass a competency test in a particular division before an assignment is given, but that sounds like it would require rules.
I guess so.
And we don't pick the judges. The people get to elect them.
Exactly. I understand that. I'm just trying to figure out a way and suggestions, having been under the pressures that go with, and I've been board certified as a circuit civil trial attorney for almost 40 years. Next year will be the 40th year as a board certified attorney. You would think I would have no trouble handling a circuit civil docket. The last 4 years I was on the bench, I had circuit civil docket, occasionally doing some other things, and there's still things that I'm finding now that I'm a semi-retired electronic lawyer, not letting my law degree go to waste. The rules are interpreted so differently by so many different people because they're interpreting them with their backgrounds. and they come from different backgrounds, and they practiced in different sized firms, and they went to different mentors, and they learned different things. So the more clear your rules are, the better for all of us. And one last little point, effective date. I checked when the major rewrite occurred in, I thought it was the 60s. It turned out it was in the 50s. They started looking at it in 1952, Justice Kennedy, and it took them until 54, June 1st of 54, to go from 141 rules to 82 rules. And what they did was they made the new ones applicable to the cases filed on or after that effective date, and they left the old rules in effect for the ones that had already been pending. Well, that works on some, but I don't know if you want to make the initial disclosures something that has to happen immediately, but the duty to supplement probably could be made effective immediately. So however you're going to do it, I think the more precise you can be in the rule language and the more attentive to the education, inevitably that anyone who is a circuit civil assignment will understand, oh yeah, and did I mention judicial rotations every 2 years?
I'm sorry, could you take 30 seconds to wrap it up?
Yes, thank you. Anyhow, the fact that judges don't stick in the same assignment, they rotate, and that means you're going to have to re-educate new people. The clearer the rules, the better. And thank you for the time, and thank you for letting me be here.
Thank you, and congrats on the anniversary.
Thank you.
Did you have rebuttal, or not rebuttal, but...
I had the privilege to speak to Judge Moe beforehand, a conferral of sorts, and she made known the concern she had about the issue with continuances. The committee had considered that. I think I know the court's not inclined to obviously delay implementation. Obviously, additional education and perhaps the final opinion, maybe it could be as simple as read the rule when that's not what we're saying, but a small word may go a long way with this issue to help give a little bit of guidance.
Okay, thanks so much. We appreciate it.
I promise I will be brief. Judge Gross-Hands, I think you're my audience on this one, so I'm going to look at you a lot. 20 days is not sufficient to respond to a motion for summary judgment in a complex case. There's nothing about Rule 1.510 that makes it special for complex versus general versus streamlined. 20 days defeats what I said about using summary judgment as a tool to bring about settlements. Settlement is the highest and best outcome for any case. It's off the judge's docket, you know. There's a movie, Shark Tale. Are you happy? No. Are you happy? No. Great. That's the best resolution. And it's a tool that I see used so often. 40 days ain't broke. Please don't fix it. I strongly advocate for 40. As for Rule 1.510D and the tolling, respectfully, if filing a motion under 1.510D doesn't stop the train, what's the point of having Rule 1.510D? And actually, I meant to bring the book with me. It says, Maria, I noticed you had your book up there with you. If a non-movement shows by affidavit or declaration that, for specified reasons, it cannot present facts essential to justify its opposition, the court may defer considering the motion, deny the motion, allow time to obtain affidavits or declarations or to take discovery, or issue any other appropriate order. If filing that motion to ask for that relief doesn't stop the summary judgment train, then why'd you create the rule? You have to have the tolling provision, otherwise the rule doesn't make sense. And Justice Kennedy, to your point, the same lawyers who don't do a good job reading become the same judges who don't do a good job reading. And I specifically wrote down...
I probably shouldn't say this, but I'm going to. Don't. I wonder, and I don't, this is not an accusation, but I wonder how much of this could be sort of passive resistance from folks that really don't like change and don't like the new rules and don't like the kind of the pressure, which is there. And sometimes people that don't like rules will implement them in a way that is least likely to make them successful.
Well, sometimes people don't take the time to do the continuing education, to read the articles, to stay on top of things. Some people like the easy way to clear the docket. If I'm not going to grant a continuance, it's going to put a squeeze on the lawyers and they're going to have to resolve it, or it's going to move off my docket. The motivations can be wide and far. But Justice Muniz, when you asked Judge Moe if there needs to be a tolling provision, she said it's probably not necessary and instinctively a court should know. And my response to you is probably not and instinctively are the words we use as lawyers when we can't be absolute. And you can't have an absolute here because all judges are going to interpret things differently. And like I said, you created 1.510D for a reason. If you're going to give effect to it, it needs to stop the train. And my question to you is, where is the harm in making that clear? It is unfortunate if it takes too much time. There are some jurisdictions where you can get 5 minutes in the morning to ask the judge to call it to their attention that you've got a 1.510D motion pending, and other jurisdictions you can't. It varies wildly, but I feel very strongly that there will be chaos if based on differing interpretations by different judges in different locations if you don't create the uniformity in the rule. And my last point is on funding. I have toured the state talking to judges and talking to lawyers and trying to prepare them that these rules are coming and that they need to be adjusting their practices and how they're thinking. And I have asked judges, because they are stressed, what would make it possible for you to implement these rules the way the court's envisioning? And the two things I hear over and over again are case managers and law clerks, and they don't necessarily agree. I talked to judges yesterday in Broward County, and they said, law clerks, we need law clerks. If we had law clerks, then we could administer things so much more efficiently. But then judges in Seminole County said the case managers are what we need. There was a judge who said, I have 300 orders sitting on my desk that need to be signed, and I don't know when I can get them done.
The thing about it is law clerks can't sign those orders.
Law clerks can't sign those orders. You're absolutely right.
I have great law clerks, but they can't do that.
I don't think they're suggesting it. I think that what she was suggesting was if I had law clerks that were doing other things, it would free up my time to...
I understand the argument. I definitely do. And I wish everybody could have law clerks as great as mine. But, you know, I think part of the colloquy about resources that, and I don't want to delay this any longer, but I do think this is an important point. I don't think it's fair to say, well, federal rules means federal resources. I think that if there is a better mousetrap, I don't care whether it's a federal rule or one we came up with, it should actually lower the demand for resources. We should be, you know, in this posture, thinking of rules that minimize the demand on resources. And if a federal rule happens to effectuate that, great. You know, and if a state rule we can come up with effectuates that, great. I think you know, in our consideration of this, I think we should break down this idea that, you know, if the federal rules have come up with a better mousetrap, that mousetrap will only work if everybody has 4 law clerks and lifetime tenure.
I'm not advocating for 4 law clerks and lifetime tenure. What I am advocating for is that I believe right now is the time to ask the legislature. The Florida Bar has almost 100,000 members the last time I looked. Let's say 50% of them are impacted by these rules. You're talking about tens of thousands of lawyers. If the sections of the Florida Bar that touch civil justice united, I know FLBOTA is on board, I know the FJA is on board, and I'm positive that the FDLA will be on board, because what we all want is the same thing. It is bipartisan. It's not Republican, it's not Democrat, it's not plaintiff, it's not plaintiff, it's not defendant. It is, we want the civil justice system in Florida, state courts, to operate smoothly. And I think that a request like that hits the legislature differently when it's supported by the Florida Supreme Court. I think this moment in time is lightning in a bottle. We have a newly elected set of state legislators and senators. We have committees that are realigning, and we should probably know within the next 2 weeks who the members of those committees are going to be. And this is an issue that makes everybody look good. Which legislature wants to say, I oppose helping the civil justice system? So It only takes a spark to start a fire. And I am handing out sparklers to any group that will listen to me when I go try to talk to them about these are the rules and how they're going to impact your practice. This is what you need to be doing to prepare yourselves. And I believe that with your support, we can create a fire that burns so brightly that the legislature can't ignore it. And I would ask that when the request is made, that you strongly consider supporting a request to give funding to the individual circuits so that they can determine what best suits their circuit to implement the rules, because we all want the same thing. Thank
Okay,
you.
thanks so much, and thanks for all your work on this. You've gone above and beyond the call of duty. We appreciate it. We're going to take a 10-minute recess.
All rise. Florida Supreme Court is now in session. Please be seated.
Okay, we will now take up Florida Atlantic University Board of Trustees versus Harbor Branch Oceanographic Institute Foundation, Incorporated, case number 2023-1470.
Thank you, Mr. Chief Justice, and may it please the Court. Andy Bardos on behalf of the FAU Board of Trustees. With the Court's permission, I'll yield 5 minutes to Mr. Shank on behalf of the amicus curiae, the Attorney General, to address the notice issue. In 2018, the Legislature and the Board of Governors amended Florida law to confer on state universities a right to approve or disapprove appointments to the boards of trustees of university direct support organizations. The Court below erred in holding that 2018 amendment unconstitutionally impairs a contract between FAU and its direct support organization, the Harbor Branch Foundation. It erred for 2 reasons. First, there is no impairment of the contract because the contract makes no provision for the selection of those directors. Because it makes no provision for the selection of those directors, there are no rights or obligations in the contract to be impaired. Second, even if there were an impairment, the public interest in DSO oversight would more than justify the challenge laws. DSOs are trustees of vast resources administered on behalf of the state university system. The board DSOs are therefore dedicated to the state universities.
Did the DCA err in considering the constitutional issue in the first place?
Yes, Your Honor, and Mr. Shank will certainly address that. The foundation did not give notice to the Attorney General, and that bars consideration of the claim, as Mr. Shank will expand upon.
You're hardly in a position to argue that, are you?
Well, Your Honor,
since you also asked the Court to decide the constitutional issue, isn't that correct?
Your Honor, we did in our pretrial stipulation identify that as one of the issues framed in the pleadings. We don't believe, though, that FAU has the ability to waive a right that belongs to the Attorney General and to the public.
Well, I understand. That's a separate issue, but
yes,
it's not something that you have much standing to argue yourself.
Your Honor, I think that
the university has standing.
I think it can be raised. I think in the Shelton case, a second DCA raised it sua sponte. I think it's something that we can raise, and that the Attorney General certainly has the ability to weigh in on here.
And it seems like it would be, arguably this whole thing is very wasteful, but it would be hugely wasteful to sort of go back to square one. I know that your argument is that if you were to prevail on this issue of the notice, that should be the end of it. But am I right that there's no controlling law that says what should happen if the Court were to go down that path? I mean, a do-over is at least an available option, right?
Well, I think what we've seen in the DCA cases that address this issue is the courts simply say that we can't address it. They don't say we're remanding to the trial court so that the AG can be given notice and that the trial court can then consider the issue. So certainly at this stage, the foundation had years to provide notice. They didn't do it. The burden is squarely on them under the rule. And we went to a trial after 6 years of litigation. At this point, I think you're right, Your Honor. It would be wasteful to go back and do it, and it would. And after all, the burden is on them.
Am I right that the first time the constitutional impairment argument is presented in this litigation is in the affirmative defenses raised by Harbor Branch?
So there are 2 different issues. One is the appointment issue. The appointment issue was raised by FAU in a counterclaim, and the foundation raised the impairment issue as an affirmative defense. Yes. Okay. So the appointment issue comes where? Like, what's the first pleading that raises the appointments issue? It was a counterclaim that FAU filed in 2019. Okay. So you came first on the constitutional impairment issue. So we sought a declaratory judgment as to appointments, and then they responded with an affirmative defense claiming that their contract is impaired. Got it. Okay.
How does decertification work? What happens what happens to the former DSO if there's decertification?
So, Your Honor, it loses its status as a DSO that supports the state university. The DSO laws no longer apply to it. It's not bound by those. It would continue to exist as an entity, I presume. They existed before they became a DSO.
And the assets, I mean, whatever they have, they just take it with them?
Yes, Your Honor. That's how I would imagine that happening.
I know that the school can decertify, but can the entity sort of say we don't want to be a DSO anymore?
No, Your Honor. They accepted the certification. There's provision for this university to decertify its DSOs, but a DSO can't decertify itself. So the foundation has used several methods to try to bring a right or obligation into the MOU to provide for the appointment of directors. One of those is the Articles of Incorporation and Bylaws, which is where they do set out how those directors will be appointed. And the trial court relied on that as extrinsic evidence of what's in the MOU. The foundation seems to concede that it's not extrinsic evidence, and they rely instead on the theory that their articles and bylaws are incorporated by operation of law into the MOU. Both of these are methods of trying to bring into the MOU something that the parties didn't put there. And the articles and bylaws are not incorporated by operation of law into the MOU because, number one, they're not laws to begin with. And number two, even if they were incorporated into the MOU, the contracts clause wouldn't apply to it because it doesn't apply to provisions that are incorporated into contracts by operation of law. That's the Romaine case decided by the U.S. Supreme Court. So the only provisions of a contract that are protected from impairment are those that the parties bargain for and that are in the contract. And we see nothing in the contract about how these appointees are to be appointed.
Can you respond to their argument about the meaning to be ascribed to the silence in the contract about additional appointments? Can you do that?
Yes, Your Honor. So they rely on a negative implication. So the contract itself says that FAU will have 2 appointees on the board. They infer from that
you shall have but 2 appointments.
Well, yeah, that's right. And I think if it were simply a question of is it 2 appointments or 3 appointments, I think they would have a stronger inference. I think they would have a stronger case. But they're drawing an inference that's even further than that. What they're saying is that the parties considered and agreed mutually, which is what the negative implication canon requires, not only that FAU is limited to 2 appointments, but that FAU has no role whatsoever in the selection of the other directors. So not only can they not appoint them, but they have no approval power, they have no other say whatsoever.
And this isn't about appointment power. This is about approval power.
That's right. This is only about an approval power, which is different, and I think that's a step too far. I think to say that because the parties agreed that FAU has only 2 appointments, and the MOU is otherwise silent as to the other directors, to infer from that the parties mutually considered and agreed that FAU has no say whatsoever in the appointment of the other directors, I think is carrying the inference too far. I think the court in this case, I think it should recognize a couple of things. One is the Article 1, Section 10, the Contracts Clause, talks about impairing the obligation of contracts. And certainly there's language in cases in Florida about impairing the value or the strength of a contract. But that's not what the Contracts Clause is about. It's not about protecting the abstract hopes or expectations of the parties. It's about finding an obligation that's in the contract, and is the obligation being impaired? And that doesn't exist here. And the other thing that I think this case that the court can establish here is how we interpret contracts. I think just as the supremacy of the text principle applies in the interpretation of statutes, where we rely on the words and we don't look beyond the words if there's a fair meaning to be derived from that, I think that same principle can apply to contracts, and it should apply to contracts. And the parties had not only the right and the opportunity, but the duty to put into the contract what they want that contract to embody. And there's nothing in this contract to suggest that the parties spelled out or agreed upon some method of appointing the directors other than the 2 that FAU appoints. And to look beyond that not only undermines potentially the integration provision that's in the contract, but also weakens reliance on the text of the contract, that the parties can rely on that to know what their rights and obligations are.
But even if this thing had said, FAU gets 2 appointments and the rest of the appointments will be done, however the board wants. It seems like we wouldn't want to suggest that the 2 parties could sort of insulate themselves from government regulation that might affect something that really, FAU can't really bargain away the legislature's authority to kind of decide how best to regulate DSOs, right?
That's right, Your Honor. Now, if there were a direct conflict between something that the parties had agreed to and a subsequent statute, then of course you would move on to if there's an impairment, you would move on to the balancing test, and that's where I think the unique nature of DSOs would more than justify this. This is not a garden variety commercial entity that has its own separate interest. These are entities that by law have agreed to be annexed to a state university and to support the state university and to do nothing else but to dedicate themselves to the public interest and to dedicate their resources for that purpose. So I think the balance is very different here from what you would see in a different context.
You raised resources. Can you address DOG Regulation 9.0114 and the budget issue?
Yes, Your Honor. So the budget, first of all, making expenditures and establishing a budget, we think are two very different things. To say that that's all rolled into this one provision in the MOU that confers sole discretion to make distributions, and that provision therefore gives the DSO complete discretion throughout the entire budget process and the adoption of its budget, I think that's overreading that provision by far. And the reason we know that the parties never even contemplated that is that the laws in effect at that time did provide for university oversight of the budget process.
Well,
so
wasn't that review? Wouldn't you say there's a little difference? Because didn't it provide for review by the university, and now it's approval?
So there are a couple of different things. One, there was a BOG regulation, and the BOG has its own legislative power in this area that flows from the Constitution. The BOG regulation provided for a recommendation by the university president to the Board of Governors, which would then review it. But there's a separate provision, a statutory provision, that said that whenever a DSO uses the property of a state university, it subjects itself to budget review and oversight in accordance with university regulations. Those are two separate provisions. And they asked for and had included in the MOU a provision that allowed them to use university property. They were familiar with these laws. They were sophisticated parties. They knew they were opting into budget review and oversight. There's no way that they could have imagined that they could, by contract, insulate themselves from that regulation. And sole discretion to establish their budget, which is what they're arguing for, is completely incompatible with any sort of regulation or oversight of their budget, which not only the BOG regulation but also state statutes provided for at the time. And I don't want to use up Mr. Schenk's time, so unless the court has further questions, I'll yield to him at this time.
Can I ask you just one quick question about the decertification? So, I mean, are these things basically captives? I mean, it seems like if they don't want to follow state law and how they're, and I don't know whether they want to remain a DSO or not, but couldn't the school just say, listen, if you're not willing to follow the appointments law and the budget review law, then we'll decertify you? I mean,
the university could do that. The
but
university
you want their money, right?
Well, we certainly, they support the university. They have supported the university. We think that it will be a productive relationship going forward. But that's certainly something that the university could do. It's not something that a DSO can do.
And so they're stuck with you guys, basically.
Yes, Your Honor. That's what they committed to under Florida law. That's the entity that they are.
And so you think that by agreeing to become a DSO in the MOU, they basically signed up for that?
Yes, they signed up for DSO status. That characterizes them as an entity. That's what they are, unless the university decides that relationship is no longer productive.
Okay, thanks.
Good morning, Your Honors. Robert Schenk for Attorney General Ashley Moody. The Attorney General is tasked with protecting Florida's laws, but it's hard, if not impossible, to protect those laws from challenges that she doesn't even know about.
Well, let me ask you about this. When the Attorney General found out about this in the course of the district court proceedings, why did the Attorney General stand mute?
Well, I believe we were first notified at the appellate level.
That's the district court, yes, I understand.
Oh, sorry.
I'm
thinking in federal court terms, Your Honor. I apologize.
In the state district court, yeah.
So I think the reason, in part, is because Lee Memorial tells us we don't have to get involved. Lee Memorial said, or this court in Lee Memorial in 2018 said that we have a right to be notified, and it doesn't matter whether we decide to intervene or not. What matters is we get notice so the Attorney General can make that calculus behind the scenes. Is this going to be a case where her participation is
Lee Memorial is a case about striking down a statute on constitutional grounds, right? It's not about impairment of a contract.
But again, right, this is a constitutional challenge based in...
I agree, but you're characterizing what Lee Memorial tells you, and it sounds to me like you're really arguing that how you read Lee Memorial told you didn't have to. I don't think it's in your interest to try and overstate the holding of Lee Memorial. Your position is we didn't have to, so okay, let's assume we remand this. What's the Attorney General's position?
Well, I also think that Lee Memorial answers that question as well when this court said that it bars consideration of a constitutional claim. And the constitutional claim here is that the statute that deals with board approval of directors is unconstitutional as applied in this scenario.
You would make an as applied argument? You would not go whole hog and say it just is unconstitutional, and by the way, Lee Memorial lets us state broadly whether or not something is a constitutional exercise of legislative authority, or whether or not it is. I don't think you're trying to limit yourself to an as-applied challenge. I'm listening very carefully to the words you select.
No. I think that we would want notice of every type of constitutional challenge against our statutes.
So that would be the AG's position on remand if this went back down?
Yes.
Okay.
Yes. But again...
So I'm sorry. Your position on remand is that you want notice?
No, I think that we don't want remand because Lee Memorial tells us that the proper remedy is just barring consideration of the constitutional claim. Lee Memorial said, or this court in Lee Memorial said, that the trial court properly decided not to consider a constitutional claim at all. In that case, there were two constitutional claims. The AG was notified about one of those claims, but wasn't notified about another, and that the party there actually tried to cure that defect by amending the notice at the trial court level. And this court still said that consideration of that claim was inappropriate.
And you don't think there's any issue with the fact that you didn't raise this to the 4th DCA when you actually had noticed that this wasn't brought to the trial court?
No, there's a separate notice provision at the DCA level, right, 9.425. And I think that we also required notice at that level, but at that point it had already, the violation of Rule 1.071 had already taken place.
Seemed like a good time to raise it to the DCA.
Well, again, Your Honor, I guess I don't want to sound like a broken record, but I don't think, or at least I believe that Lee Memorial doesn't require us to intervene in order to protect our rights about notice. I suppose in the future we may decide whether to actually make this same argument at the DCA level. But again, I think this issue is very important to us because we need to be able to act at various stages of the proceeding to protect our rights and interests.
But in Lee Memorial, part of the issue there was that the district court had actually decided an issue that had not even been argued by the parties to it. It just seems like that puts that off in a different category than what we're talking about here, where this is a very live issue, and the Attorney General is told about it and just says nothing. So I don't. It seems like there ought to be some kind of principle here that even the state has to speak up when they have the first opportunity to do so. And again, I understand what you're saying about Lee Memorial, but and maybe I'm missing something here, but I think the facts there are a little set this apart from the point that you're trying to make. And I say this as someone who believes that this right of the state to come in and defend the constitutionality of laws is very important. I've written about that, which you may have cited. So it's not that I think it's unimportant, but it's a right that has to be utilized. It seems like to me. I'm just wondering why it's not a right that has to be utilized when there's the opportunity is given, and it might be that the Attorney General would have said, no, this has to stop. We didn't get the notice down there. It ought to be reversed on that basis, or make the constitutional argument that there's not an impairment. But to just kind of ignore it, I wonder about that. So, but that's.
May I briefly respond, sure. Your Honor? I understand the concern there. I think that we are just very concerned about cases in which we may not get notice from the parties because the parties may drop the ball. And it may take years, as in this case, for us to actually receive proper notice. And at that point, the damage may be done. And so
But it just seems like to me, at that point, it's the time to come in screaming and howling about it, about what, rather than to wait till it comes here. I mean, what if it's not? What if this comes up here and it's not even? You aren't even notified when it comes here. You're going to come later and say, "Well, we didn't have notice, and that's what you did was not proper." I mean, I don't know.
Well, that's what I think Lee Memorial calls for, Your Honor.
Don't you think that sorry?
No, go ahead.
I mean, the AG can certainly waive. It's entitled to be heard. So why would we not apply that same principle in this specific case at the district court level? If the AG was noticed at the district court level, I know you say the violation has occurred, but that's also a violation that the AG it would be within her discretion to waive. So if the AG did not appear in the district court case, why would we not treat that as a waiver of this particular argument? That in this case the notice wasn't served for whatever reason, district court, nobody appeared in that case, district court could therefore assume that it's waived.
I don't think that we can just assume that the right has been waived like that. Obviously, Harbor Branch has actually never complied with the trial court rule. It applied with a separate appellate court rule. But again, I think typically when we think of waiver in terms of individual rights or rights to a party, typically that has to be an intentional relinquishment.
Well,
it's not something that's just...
To Justice Sasso's question, then, if we wanted to decide whether or not the Attorney General had waived, what evidence would we look for to determine that there had been waiver other than silence?
Yes, and typically when you look at something like that, we typically treat something like that like forfeiture, not necessarily waiver.
My question is, what would we look to for evidence of your choice to waive it, if not silence?
I think that is the only evidence in this case. I don't think that it has...
That's not a very...
But what other evidence would there have been? Would you file something?
Oh, I think certainly, yes. We could come into the district court level and we could, of course, say, well, yes, we understand that.
So we should assume that once you know at the district court level and you stay silent, but you also don't file anything waiving it, that then you wait until there's an opinion from the district court, you wait until it's here on merit briefing all the time, all the judicial resources, and then you use the sword of this rule for the first time. That's what you'd ask us to do today.
Well, certainly this rule might strike this holding might seem to some as harsh, but that's just the consequence of this bright line rule. I mean, we have other rules that have very strict consequences, such as the time to file for an appeal, and you miss it by 1 day, and that's it. So that's just a function of protecting this very important interest of the Attorney General to make sure that she can do her constitutional duty to defend Florida statutes, Your Honor.
Okay, thanks so much.
Thank you so much, Your Honor.
Thank you.
Mr. Chief Justice, and may it please the court, I'd like to start with the issue of notice, because this is a clear case where the Attorney General waived those rights when they were given notice in compliance with the rules on appeal.
Well, I wouldn't know if this is a substantive statute that provides a public right at the trial court level. The statute does not say anything about appeal. It says when the complaint is served. And so if we have a procedural rule implementing as a procedural mechanism to implement that notice at the appellate level, that's not amending the statute as to the substantive requirement that be served along with the complaint. So why would we not give effect to that, the legislative prerogative in that case, to require it at the trial court level and do, as the AG says here, which is treated as dispositive of any constitutional claim?
Well, several reasons, Justice Sasso. One of them is that you can still waive that right. There's no reason that the waiver can't apply. It's the same right. It is the notice about constitutional issues, and I'll get to the as-applied facial
you agree,
challenge
though,
issue.
there's no basis for us to find waiver at the trial court level from the AG's standpoint, correct?
Not at the trial court level, but at the appellate level. And once it is waived at the appellate level, they can't come back to this court and raise the issue concerning the trial court level. What if FAU had never filed a notice of appeal at all? The case would never come up here. Many times there could be errors at a trial court, but if they're not preserved and waived, or not preserved, they are waived, and this is no different. And the Lee Memorial case, as Justice Kennedy pointed out, is different. That is where the constitutional issue was raised for the first time on appeal when the parties did not brief the issue, And it was after Lee Memorial was decided that the rules of appellate procedure were amended to provide the additional requirement, the requirement of notice on appeal to the AG. Now, the second point I would make is that the nature of the challenge here was not to strike the statute as unconstitutional. It did not call into question, to use the language of 1.071, the constitutionality of the statute. It was rather a question of whether or not, as applied to this DSO agreement, there was an impairment of contract. Now, this court has not decided that issue before, but in the federal system, as we've briefed, and in 3 other states, similar rules to this have been interpreted as dealing only with facial challenges, where it has an effect beyond this case. The ruling here has no effect beyond this case. And so that's an important distinction which we think should be followed.
Let me ask you about that. And I understand your point and the force of it, but it does seem to me that to set up a rule that this requirement would only apply to a facial challenge would be problematic, because there are some as-applied challenges that kind of go to the heart of what the legislature is trying to get at. It might not be a facial challenge. It might not be framed as a facial challenge, but it might really be getting at the main thing, that a case that involves the primary application of the statute. So wouldn't it be problematic for us to have a distinction like that, given that?
I would say several things. I think that there are lines drawn, and the federal courts seem to have drawn it between facial and as applied, but this court could draw it in a different place and say, for this case, in a case which only involves the application of a statute to one particular memorandum of understanding involving one DSO, that's not the type of issue where it is necessary to reverse and go back to square one. You could reach that under the harmless error doctrine too, I think. Secondly, you can also avoid the constitutional issue here entirely by the argument we've made, and admittedly it wasn't reached below, the court reached the constitutional issue, but there's a serious question of retroactivity when you're applying this new statute to a memorandum of understanding that is already in effect.
Well, but go on.
Don't our precedents, the ones that we've done on this retroactivity issue lately, kind of indicate that, it'd be one thing if FAU was saying we want to retroactively approve people that have already been on the board, but as long as the activity that's being regulated hasn't happened yet, then it's not, the retroactivity analysis doesn't kick in.
I think there's cases on both sides. We cite Hahn versus Hahn, for example, in our papers, where there was an effect on future children by applying a statute to have marital authority.
This is a contract that is being performed, and so I presume the contract is governed by the law of the state of Florida, right?
It is, but in this contract, the parties did not agree to be importing the law that changes in the future.
No. But general choice of law provisions, when you say a contract is governed by the law of a state, you mean that during the term of the contract, while the duties of the contract are being performed, those duties are as defined by the law of the state. But
now, if you're applying the statute to that contract to apply in the future, I think that is...
It's not the future, it's the present. This contract is binding between the parties, subject to your constitutional argument. Yes. I think this is a loser. The idea that you need to make it retroactive to the time of contract formation would swallow the need to have a governing law provision in any agreement. That can't be the law.
Yeah. Let me, if I might, Your Honor, mention a third point, which I think responds to one of the questions from the court, which is the remedy here is a remand. And it's sort of a wasteful remedy because they haven't expressed any view on the merits that the Attorney General wants to consider. They could have done it in this court. They could have done it in the 4th DCA. But there's authority for that in the Seminole County versus Braden case at 1st DCA, December 2023, where it said the remedy for failing to notice the Attorney General under Rule 9.425 is giving the Attorney General an opportunity to appear at oral argument and file briefs on the constitutional issue. So
why is that not a second bite at the apple? We obviously have a bunch of cases along that line of thought. Why wouldn't we apply that here?
Well, it would be wasteful to just on this procedural ground not reach the issue or remand, because given this is an ongoing issue, a new case can be filed raising the same
Is
claim.
waste
It's not
ever
on
a
the merits.
justification? I mean, I'm just trying to think of any of our cases where, in applying a remand, we've considered waste rather than, procedure.
Well, I think if there's a point to the remand, then it makes sense to remand. But that's the most extreme thing is to remand. I think the other option here would be to say it's harmless error or waived because the Attorney General knowing, and there's no other evidence in silence to show that it's a knowing, intelligent waiver of the right, waived those rights in the 4th DCA, and has not even in this court expressed a view on the merits of the issue. And on those merits, if I may turn to that, Your Honors, our position is anchored in 3 facts or points. One is that the plain language in the Memorandum of Understanding, when it talks about 2 directors, it should be interpreted as meaning to and not import a right to approve other directors. Secondly,
can you tell me about what importation you're talking about? It just seems to me like they've stated a fact. There is an agreement between the parties that there is an appointment power as to 2. Number 1, it hasn't said anything about approval power, and number 2, it hasn't spoken as to the other members of the board. Tell me about this importation.
Well, you have in the Memorandum of Understanding in Section 4, which is the section that all of the issues here arrive from, a provision which says that FAU needs to approve the articles and the bylaws of the foundation. They did so. Those articles and bylaws provided for a method of appointment of all the other directors, which would be by the foundation itself. So I think whether one reaches that by that incorporation through Section 4 of the Memorandum of Understanding, or simply as I think the lower courts did, as extrinsic evidence to deal with this issue of latent ambiguity, you reach the same conclusion.
What's ambiguous? What's the ambiguity? Tell me, when something is ambiguous, it is capable of 2 possible readings. What are the 2 possible readings of you have the power under this contract to appoint 2 board members? What's the ambiguity?
Well, I think we would argue that on its face it isn't ambiguous because of the rule against the negative implication canon, which applies here. But at minimum, at worst, there's an ambiguity.
Negative implication canon, respectfully, how the negative implication canon is something we use cautiously because it is context determinate, and usually it's because we've enumerated several things and excluded something. What is the enumeration of things that I'm applying the negative implication canon to here?
Well, I believe when you say that you have the right to appoint 2 directors, by negative implication, it doesn't mean that you have any right with respect to the others.
What's your best case for that being a good use, a proper use of the negative implication canon? Because I can't think of one.
Well, we have S. Crane Rentals, which is 429 Southern 2nd at 73, rejecting the argument that the absence of a provision on cancellation rights created a latent ambiguity. So I think that would apply there. And I would note that Scalia and Garner's text indicated 109 to 110 that when a legal text declares a specific mode of appointment, it necessarily implies a prohibition on all other modes.
Modes. Can I ask you what's the? I'm trying to. So as far as the nature of the vested right that you say is here, does it matter to your claim that the legislature chose to make the trustees the approving authority? I guess I can't remember if it's the trustees and the BOG or whatever, but what if they had said, we're worried about DSOs and how well they're doing their job, so we want to make all board appointments subject to approval by the Attorney General or approval by some new advisory group or whatever that we're setting up. I mean, is it your position that basically because FAU and your client had a kind of an at least implicit understanding that the FAU is going to get 2 and the foundation is going to do the others, does that mean that they've then created this right that the legislature can't regulate in a way, even if it's in ways that don't even involve FAU itself?
I think it would still be an impairment of contract, whether they vested that in the Attorney General, the trustees as they did, or some other party. And I think that is the teaching of this court's decision in Citrus County, which I think is very directly applicable and controls this case.
So that's an incredibly broad principle then, that And maybe the answer is the sort of the next step in the analysis, which the Citrus County case didn't get to, which is the extent of the impairment and the public interest at stake. But I mean, it seems like it's one thing to kind of have rules that go to things that are, party A is obligated to B, and we're going to give you all these assets, or you're going to buy them from us, and then we're going to convert to a DSO. But you're basically saying that on all these things, whether they're addressed implicitly or explicitly, that essentially that you can insulate yourself from regulation.
Well, Mr. Chief Justice, consider the alternative, which is that a party to the contract, which FAU is, and the state, they're part of the state, that the state can come in there and unilaterally rewrite that contract. They could change any sorts of things unless the impairment of contract
and part of it gets to the obligation issue too. I mean, this really wasn't. I mean, if you read this thing, I mean, I'm sure you've read it a million times, but just from my reading it, I mean, the main point of this is to effectuate the purchase of these other assets, and then, it kind of acknowledges that the foundation is going to become a DSO. But I mean, DSOs are regulated by state law and regulations of the universities. I mean, the point of this contract wasn't to purport to kind of regulate sort of the ongoing kind of DSO workings of this entity.
Well, we think first of all, I think it's important to recognize that this DSO came to this and gave $90 million worth of land. It now has an endowment of funds that is raised. It's not state money, $95 million as of 2021 in the record. So the state is seeking to gain control over this. The record shows in 2015, they went to the foundation and said, we want you to use these funds to make a $50,000 contribution for the football stadium. So the foundation is concerned about that state overreach. The record is very clear that is why this was a heavily negotiated memorandum of understanding where the parties agreed to preserve that independence of the foundation.
It seems like to me that really what was going on here is there's this reluctance to be a DSO that is kind of overcome, and this you've got this memorandum, and it really kind of amounts to trying to put a square peg in a round hole. You want to be something really kind of different than a DSO. But you signed up to be a DSO. At the end of the day, it seems like you signed up to be a DSO and came into this area where that is highly regulated, where what you've got is basically has to be used for their benefit. And so that's a public matter. And it just seems like, I know about Citrus County, and I think this is a little different, but what I might think about Citrus County. But I just think when you sign up to go into a public, into the status of a public entity like this, that is highly regulated, and obviously subject to future regulation. Then to be making the complaints you're making, it seems to cut against the context.
Well, I think Citrus County also involved public and enterprise.
That's true.
Which I know your Honor's opinion in that dealt with, but here you're dealing with an entity created by private individuals with private money that negotiated that memorandum of understanding. If that doesn't have any legal effect, then why? It means that it could be changed at will. The remedies which the state or FAU has is, number one, the decertification process, which the Chief Justice asked about, which is open only to FAU. It doesn't ratchet in the other direction. Second, they can enforce the requirement that funds be used for the purpose of FAU. If for some reason the foundation was going to do something that didn't meet that requirement, they have the courts to enforce the requirement.
But
so there are checks and balances.
The contract is really irrelevant in the sense, because that if they wanted to enforce that, they'd be pointing to the state law. I mean, this contract really isn't about that. It's an interesting thing because obviously we respect our precedents as much as we can, but to the extent that it doesn't get to the sort of final part of the analysis in that case, could you kind of address why we shouldn't kind of maybe read Citrus as far as it goes, but then apply the analysis that it doesn't do?
I would say two things, Your Honor. First of all, In Citrus County, the court didn't do the balancing, but I think that's because the nature of the impairment there, like here, is severe. It goes to appointment powers and approval powers, and it goes to the type of restrictions on disbursements and expenses that are involved here. Remember, this court said in the Polonio case and echoed this in the Searcy case that virtually all impairments of contract are not lawful. So I think, and this court cited Citrus County with apparent approval when it got to the Searcy case. So I think there's two ways you can reach the decision, saying that first, directly under Citrus County, the nature of this impairment is such that it cannot be justified. Second, the court can say, we're going to apply the balancing test. As the lower court did, they said there was no evidence presented here that would support that there was either a state interest at work here and there was no evidence to deny that it was a severe impairment of the rights.
But the state interest is kind of self-evident. I mean, it seems like it's just sort of a value judgment. I think that's one of the problems with all balancing tests in general, especially ones that get into, public interest and that sort of thing. But I mean, it's pretty obvious why, if I'm this state and I think DSOs need more oversight. I mean, this is kind of a arguably relatively kind of lightly intrusive way to go about doing that.
And for all the DSOs that don't have a memorandum of understanding where you would be breaching a contract, that would be true. But if it breaches a contract in a severe way, then the state has to do more than just point to that generalized concern, but to either disprove that this is a severe impairment or to have evidence that supports that there was a justification for the law to do this. Otherwise, the balancing test does not matter. With the court's permission, I'll save the balance of my time for rebuttal on the cross appeal.
Thank you, Your Honor. I'll address the Citrus County case very briefly, and certainly there's a surface resemblance with Citrus County because it also concerned in part the appointment of directors, but that's about where the similarity ends. So the Citrus County case is different because there was a contract provision on this very subject. There, the allegation was that the Articles of Incorporation were impaired. And under Chapter 617, that's exactly where the process for appointing directors must be set forth. So there were provisions on the appointment of directors in that case that were being rewritten by the law. Not so here. They talk about the contract being negotiated, but this issue was not negotiated. There's nothing in the contract that talks about how directors are appointed other than FAU's two directors. The other thing that differs, of course, about Citrus County is that the court didn't apply the balancing test. And we know, on one hand, the state interest is much more significant here because there the legislature had enacted a special law aimed at a single contractual relationship after disputes had arisen. It did not enact a generally applicable law that regulated with an even hand. There was no attempt to regulate hospital leases on a public statewide basis. The other side of that is the extent of the impairment, which was very different in Citrus County than it is here.
How do we do the public interest thing in a principled way? I mean, the public interest in something like this is always going to seem kind of overwhelming in relation to one entity's desire to pick their own board members. I mean, how do we do that? How do we do the public interest thing in a way that's just not us kind of subjectively trying to decide how good of an idea this is?
Yeah, well, by its nature, Your Honor, it's not a bright line. I think here, though, we have overwhelming evidence of what the public interest is. I think Your Honor's point about how it's an obvious interest here. There's really nothing too controversial about it. DSOs hold vast resources, $8 billion in assets dedicated to state purposes for the benefit of universities, students, donors, taxpayers. There really, I think, can be no reasonable quarrel with that. I think every case will be context specific and fact dependent. I think it'll depend on the record, but in this case, I think we've easily cleared that bar. And I see my...
You can go ahead.
And so just to conclude on Citrus County, I think the other part of that is the severity of the impairment. In Citrus County, the court considered in the aggregate 16 different subsections that altered in different ways the governance of that foundation. It was not simply about appointment of directors and the approval of those appointments. And so the court considered something where there was a significant fundamental shift in the governance, financial governance, leadership of that entity that is really nothing like this case. And so I think Citrus County is distinguishable on any number of grounds. And so with that, Your Honor, we thank you. We'd ask that the court reverse as to appointments and otherwise affirm.
May it please the court, there are three issues I'd like to address in rebuttal based on what was said. First, Citrus County is directly applicable because there this court said that imposing new obligations by a statute, even if it didn't change things in the existing agreement, could itself be an impairment. So even if you had silence and didn't have the reference to the two directors, you're still imposing new requirements on the contract. And these are significant. What could be more significant than the issue of who are the directors and the issue of the budget? And that's the second point I'd like to make. It was specifically negotiated to have sole discretion over expenditures. Our cross appeal is predicated on the fact you cannot have sole discretion over expenditures if your budget is subject to the approval of FAU. Sole discretion means exactly that, discretion you have that is not subject to someone else coming in. And in fact, the record shows that the CFO of FAU, Mr. Atwater, admitted, he says that if you have control over disbursements, then you can't have these type of disbursements unless they're in the approved budget. So the control over the budget controls the disbursements flatly against the sole discretion language. Third point is how do you weigh the public interest and do the balancing? Well, two courts in this case, the Circuit Court and the DCA, have found that in this case there was no evidence that was presented to show there was a substantial public interest to apply this statute to this DSO, or that would compromise or support the issue that this was not a severe impairment. So I think you have to look at the fact that here you have the state changing something that goes to fundamental rights of appointment, fundamental rights of sole discretion over disbursements, where both courts below have found there was no evidence presented to support the interest that now the state is raising. So unless the court has questions, we believe that the first issue, in which the appellee should be affirmed, and the second should be reversed. Thank you, Your Honor.
Thank you. Okay, our last case today is State Attorneys for the 2nd, 7th, and 9th Judicial Circuits versus Florida PACE Funding Agency, case number 2024-0652.
Good morning, and may it please the court. My name is John Tucker. There are going to be three of us that will argue today. I'm going to argue first 10 minutes, and I will be addressing Rule 1.010 that the court had asked to be addressed. I will also address the issues regarding Rule 1.540 and the jurisdictional appeal issues, and I will also touch on the due process or fundamental fairness issues that arise from the trial court's error of addressing matters relating to the home rule powers of the counties and the obligations of the tax collectors when they were not present at the bond validation hearing. Ed Guedes, with hope of Chapter 75 and the court's consistent prior precedent with regarding the not allowing collateral matters to be decided in such proceedings, And then last, Mr. Golimbieski, on behalf of the Attorney General's Office, will confirm that it's the state's position regarding the limited scope of Chapter 75, the role of the state attorneys that are involved in those bond validation proceedings, and the consistent precedent of the court, again, barring collateral matters. Before I begin addressing Rule 1.010, I want to say on behalf of the 15 counties and 41 tax collectors who are appellants in this case that we appreciate the opportunity to be heard on matters that are critical regarding their home rule powers and their constitutional rights and duties that were determined in the final bond judgment when they did not have an opportunity to participate. They would not have an opportunity to participate until we filed the Rule 1.540 motion. Also want to say that we appreciate the opportunity that this court has to render rulings on these issues that can be used in the 15-plus trial court and intermediate appellate court proceedings that exist around the state that are addressing a lot of these same issues, in which, in those cases, FPFA is arguing that the decision that we're talking about today is res judicata and cannot be raised. So let me turn to Rule 1.010.
Can you start, because I think it fits within the subjects that you're speaking on. Just the threshold issue, the Constitution gives us jurisdiction over final judgments in bond validation cases. Typically, we treat review of orders rendered and on motions for 1.540 as non-final appeals. I know there's MISE out there, but do you think MISE is consistent with the plain language of the Constitution, just on the final judgment, non-final order?
Yes, Judge. And I think they specifically said in the MISE case, we have jurisdiction. And then they went ahead further on and said, we find no merit in the argument that the order was wrong.
Can you justify that without MISE?
Pardon?
Can you justify that reasoning without MISE?
I will tell you, Judge, that every case that I've read, even the cases that they cite that say that where they say that there was not that they couldn't challenge the appeal later, they couldn't challenge it because it wasn't outside of the appeal. Every case I've seen has been a direct appeal because they address the judgment and they relate to the judgment. Every case, whether this court's come to this court and this court has said, that they can't bring it because they did not bring an appeal, they were not a party. Any of those cases, there's not a single case that I can find or that anybody cited that didn't, when they're addressing matters that were in the final judgment, that didn't travel directly to the Supreme Court like this did. And the Rule 1.010 that the court asked specifically says, and it confirms that this court should and that the Rule 1.540 motion was appropriate. The first sentence of that rule says that the rules apply to all actions of a civil nature and all special statutory proceedings in the circuit court. Plainly, the Chapter 75 was a special statutory proceeding. The second sentence says that the form, content, procedure, and time for pleadings in all special statutory pleadings shall be as prescribed by the statutes governing the proceeding unless the rules are to the contrary. This is, as this court well knows, the term pleading is a term of art that means, as decided and determined in Rule 1.10, pleadings are complaints, answers, counterclaims. They're not motions. In this court, I would cite the court to its own decisions.
But it doesn't just say pleading. It says the form, content, procedure, and time for pleading.
Right.
In all statutory proceedings shall be as prescribed by the statutes. It sounds like everything related. Form, content, procedure. And procedure would include whether a motion is fileable or not, wouldn't it?
But all of those words, Judge, have to be taken as modifying or addressing pleading. In other words, if you were to read it and you were to say the form in all special statutory proceedings would make no sense. If you said the content in all special statutory proceedings, it wouldn't make any sense. It has to mean pleading, and if you look at the court's own decisions, and I will give you, and this isn't in our briefs because it was raised afterwards, but there's the Pro Art Dental case and 986 Southern 2nd, 1244, which is this court's decision in 2008, and in the Green case at 730 Southern 2nd and 1261, which is this court's case in 1988, both said pleading means, just as Rule 1.10 says, a complaint, and they specifically said it does not mean a motion. In those cases, they involve motions to dismiss and others. There's a distinction made that this court has recognized. So the rules of civil procedure apply, including Rule 1.540. And that's what is recognized by this court in the Mize case. It's also consistent with the court's decision in the Pittman case and the Goen case that we've cited. Where
in Mize, did we actually discuss that?
You actually did, yes. In the Mize case, there were three things that were before the court on appeal. One of them was the case number 38,200 is an appeal from a post-judgment order arising out of a validation proceeding, Rule 1.540.
But that case doesn't discuss the circuit court's jurisdiction to consider 1.540.
It did
proceeding.
Not.
Right.
Well, the court certainly didn't have any problem with it because later on it's...
Well, I mean, I know the holding in Mize, but my question was, did Mize discuss Rule 1.010?
It did not.
Okay.
It did not. But the other cases that I cited, the ProArt Dental and the Green case, they do. They talk about in a special statutory proceeding that this is what's meant by pleading, this is what's meant by motion, right? And motions are not pleadings as it's related to the Rule 1.010. This court in the Pittman case and the Goen case that we've cited, those cases also say that Rule 1.540 is just the rule that this court has enacted in order to allow a procedure for parties to come in to allow the court to exercise its inherent authority to correct judgments. Where there is something wrong with it, the court has always had that inherent authority. And if you read those cases, they speak to it and say that's what allows people to use the 1.540. So then how does the trial court get around it? The trial court gets around that by saying that Chapter 75.09, the forever conclusive language that seems to be the mantra in their brief, that means nobody can challenge anything about anything after the appeal period is run. And that's wrong for a lot of reasons. But I would submit to the court that the first reason it's wrong is it makes no sense. If you take that argument and take it as true, it would mean that whatever got in the final judgment in a bond validation decision, whether it be by accident, by guise, by whatever, that nobody can challenge it. So in a bond validation proceeding, if it's forever conclusive, you could put in there that anybody in this courtroom now owes the state of Florida $10 million. Anybody in this courtroom is convicted of a felony and has to serve 10 years. And under their interpretation, it's forever conclusive. Nobody can touch it.
There's appeals. So it's not, and that's the issue here, isn't it? That an appeal wasn't taken.
Pardon?
That an appeal was not taken. That
an appeal was not taken. So, for example, in this case, if they had said in the final judgment, John Tucker now owes the state of Florida $10 million. I was not a party. I'm not in the circuits. I couldn't come in here and file a Rule 1.540 and say, how can that happen? And they would say, I'm sorry, Mr. Tucker. It's forever conclusive. You didn't take an appeal. Well, I didn't even know about the case. I wasn't a party to it. I couldn't have taken an appeal. It's also wrong because of Mize, which specifically addressed it. It's also wrong because of the Green case that we cited, the City of Gainesville case that we cited, which I would recommend that the court look to if they haven't already looked to. In the City of Gainesville case, there was an argument that these things are forever conclusive, collateral matters. And the City of Gainesville was in the case. They were the ones saying this is a collateral matter being decided. It's outside the bounds of Chapter 75 proceedings. And what the court did is they said, look, our prior decisions that say forever conclusive don't mean that if there are collateral matters being addressed that they in fact can't be challenged. And so what the what the City of Gainesville case said is, look, I'm remanding this to the trial court and they need to delete or strike from the final judgment all of the collateral matters. But otherwise the bond judgment is affirmed. And that's what we seek in this case. And it's very important because we talked about all these other cases that are pending around the state. If FPFA wants to come in and argue that Palm Beach County, one of my clients, cannot restrict and put in consumer protection ordinances that protect its citizens from the possible loss of their homes, or any of the other counties or tax collectors, then they need to come in and challenge that where we have an opportunity to raise those issues. The problem in this case is that the trial court decided those issues without it being raised to the trial court, buried in some long pleadings, buried in some long judgments, and talk in vague concepts of general law, and also saying this is black letter law. And then when it gets finished and the appeal period runs, they come out and say very different than they were saying to the court. This is res judicata. So if you can delete this from this bond final judgment, it goes back, and they want to raise that, then they're welcome to do that. Bring it to Palm Beach County, and then they can decide that. When somebody is there, the issue is framed, the issue is addressed, and can be defended. It is absolutely wrong for FPFA to be able to go in those other courts now where they're being contested and say, it's res judicata. You cannot address this. Judge, you're bound by this. Palm Beach County and all the other appellants are bound by it. That is what this is all about.
And are you, though, is this argument, is it tied to the statute, or are you just kind of suggesting that we make this a doctrine as far as this distinction between what you're calling the collateral matters? Because, I mean, the collateral matters isn't in the statute, and it seems like the subject matter of these things that you're arguing over obviously relates to the, collection and assessment of taxes and all that. So it's not obviously outside the scope of things that the statute wants to make final.
Mr. Geddes is going to address that, Judge, but let me just speak to it and answer it simply this way. This same entity in 2011 got a bond validation judgment and issued bonds throughout the state for a decade. Without the need to bury in that bond validation judgment anything that said Palm Beach County, Leon County, they can't have ordinances. They were able to do it. The Chapter 75 and this court's consistent historical precedent going back decades says all that the court should be considering is the limited scope is whether or not the bond is valid, whether it can be validly issued, not all these other things. And Mr. Geddes will address that. Let me address
have bonds been issued under this?
Bonds have been issued.
Okay, so bonds have been issued. Well, don't the bondholders rely on all the enforcement mechanisms and that whole, it may be buried, but bondholders rely on things that are buried in the documents. And so I'm having trouble understanding why the bondholders would not be entitled to rely on those specific mechanisms that are provided for in what's been adjudicated in the circuit court. Tell me what I'm missing there.
Well, they can't rely on something that is wrong, that is fundamentally wrong and void. And if they didn't,
there's a rule of finality. I mean,
well, Judge, that's what Rule 1.540 is. That's what the Supreme Court has said over the years, that this is to allow the court to use its inherent authority to correct things that are wrong.
So we could intervene and correct if the note contained a usurious interest rate. You're saying we could intervene to say, oh no, that violates the state usury law.
No, well, what I'm saying, Judge, is if you actually look at the cases, I'm not sure that the parties that are outside of the circuits that were noticed right through the publication, their state attorneys, that they could even intervene, because they're not parties. There are cases that the Supreme Court has issued saying if you're outside, you can't. It's supposed to be limited to the scope to the people, and the parties have an interest in the property that could be affected by these bonds, that's why in Chapter 75, what happens is you give a notice not in the whole state, in this instance in the 3 geographical areas, and then you also notify the state attorneys, the 3 state attorneys, right? And they want to say, well, one state attorney, the court said, one state attorney they all represent the state. Well, that's nonsense. If one represents all the state, why do they have to notify 3? And so, and again, I would ask you, let me make a couple of quick points. The trial judge said that it was untimely. We braced this argument, the motion argument, on 3 parts. One was voidness. The case law is all consistent that whenever it's void, it's void. And time cannot make something that is void valid. Okay, so that's not. If you look at the issues regarding the other, which was surprise and misconduct, if you look at that, there's no substantial evidence to support it. The evidence is, as soon as parties found out about it, they started acting, telling the FPFA, we don't agree with this, you need to do what we've been doing for the last 10 years. When FPA didn't do that, there were lawsuits filed, both by them and us, saying you can't do it. When we started to find out that there's 15, 20 of these around the state, they thought the parties got together, the counties got together, and tax collectors said, what's a better way to do this? We need, particularly where they're arguing race judicata in all these locations, we need to go back and file a Rule 1.540, and that was done as quickly as possible. When you figure that we're...
Can you take 30 seconds to wrap up here?
Okay. Thank you.
Okay, thanks.
May it please the Court. Edward Geddes on behalf of the appellants. Let me address first your question, Chief Justice Muniz, about where's the foundation for our collateral matters argument. It derives from two sources, I think. First of all, there is certainly an abundance of case law from this Court where, over the decades, it has examined bond validation judgments, determined that certain decisions rendered as part of that process were deemed collateral, in other words, not directly related to the issuing authority of the bond issuer, and struck them, directed the trial court to delete those provisions from the judgment. So there's a substantial body of case law.
But that body of case law speaks to judgments, right?
It does. Each one of those cases, with the exception of Mize, right, which is unique, each one of them arose from a judgment. Yes, correct, no question. The second portion, and I think there's a statutory foundation as well as the precedential case law one, which is 7509. And what it specifically says, when it's talking about what aspects of a judgment are forever conclusive, it directs that conclusive effect. I'm going to read from the statute here. Property owners, taxpayers, and citizens of the plaintiff, and all others having or claiming any right, title, or interest in property to be affected by the issuance of said bonds. So the finality, Justice Kennedy, that sense of, well, what can the bondholders expect? What can they rely on? Goes to this question, which is, who's bound? For whom is this forever conclusive effect going to be applied? None of the counties own property that were going to be subject to the bonds. Neither do the tax collectors. None of those entities or individuals should experience a forever conclusive effect from the judgment. And respectfully...
Sorry, what language do you think limits that?
I'm sorry, Your Honor?
Yeah, can you just repeat what language you think limits the parties? Because, I mean, to my read, it seems pretty broad.
It says
all others having or claiming any right, title, interest, or property.
Right.
Or any way affected thereby by the validity of the bonds. I mean, there's a lot of ors and any's and...
I understand. It's a very, very long sentence. Written in a better world.
And it includes any remedies provided for their collection, the collection of the assessments, right?
I understand, but you don't get to the remedies if the judgment in the first place didn't reach the parties who are now complaining that this is overreached. So the language, to answer Justice Hassel's question, it says, such judgment is forever conclusive as to all matters adjudicated against plaintiff and all parties affected thereby, including all property owners, not the counties, taxpayers, not the counties, citizens of the plaintiff, not the counties, and all others having or claiming any right, title, or interest in property to be affected by the issuance of the bond. neither the counties nor the tax collectors have a right, title, or interest in any property that is going to be affected by these bonds.
But it goes on and says, or to be affected in any other way thereby. I mean, it just seems like they're trying to cover the waterfront here, like anybody that's got any interest or asserted interest in this is concluded. I'm just reading it.
Right, but by that token, then, you could essentially have, as Mr. Tucker suggested to you, could have anything thrown in there. Any kind of declaration, which is essentially what happened here. FPFA obtained...
You could put a bill of attainder in there, and that would...
Excuse me?
Put a bill of attainder in there, and that would work, right?
It's anything. FPFA
I guess my question to that, though, is like...
I'm sorry,
I might not agree with. No. I might not agree with that if I was as an idea. That it's a good idea, but what is the law? It seems to me that there is a legislative scheme to ensure this kind of quick procedure, if that's what the legislature bargained for. I'm just seeing, like, textually, I understand the parade of horribles that you're saying, but textually, where is it indicated that that's not an intention, a specific intention of the legislature?
Because as this court held in the City of Gainesville case, right? And it was specifically confronted with this very argument, which somebody in there said, hey, Lipford stands for the proposition that forever conclusive means forever conclusive. You can't come back and challenge it. And what the court in the City of Gainesville said, no. That's not what we meant in Lipford. Forever conclusive applies to matters decided that are not collateral matters. So in order for this court to somehow conclude that now...
So that's definitely... I hate to bring this up, but what about 75.17? How does that fit into all this?
I agree, Your Honor.
We've got this language about being conclusive, and then we've got this specific authorization of commencement of action after validation, but which seems to be somewhat limited in its scope because it's challenging the validity of any bonds or certificates, or to prevent the use of any monies derived from them, and requiring an affidavit of good faith, and gives this requirement that state with particularity why the objection was not made part of the validation action. So this is there. It puzzles me how this fits with the other provision, and I realize you all have not invoked this, okay? Because I guess you're not really challenging. It's your position you're not challenging the validity of the bonds or certificates. You're challenging these, what you assert to be collateral matters. So I can understand why you wouldn't invoke it. But trying to figure out how all this fits together, it seems like this is part of the puzzle.
I agree. Thank you for hitting the fast forward button on my argument, Your Honor, because that's where I was heading next. Because 7517, at a minimum, and I too struggled with how do you bring all of this together. But at a minimum, it suggests that the legislature certainly contemplated that just because you have a bond validation judgment and the time for appeal has expired does not mean that the courts cannot revisit the bond validation judgment. How you reconcile that in particular cases, I can't speak to universally. But I do see 7517 as this doorway that potentially opens up a court revisiting it. It doesn't speak to the mechanism. It doesn't say thou shalt not use 1.540 or you have to file an original action. It doesn't speak to any of those things. It just suggests that even if you are going to challenge the bonds, and we're not, I think we've made clear, we're not saying that the bonds are all invalid. We're just suggesting that the collateral matters that this court said in the City of Gainesville have no preclusive effect cannot be forever conclusively determined. And so that's what the 1.540 reaches here. And I think this court has previously... I'm sorry, go ahead.
No, I'm just trying to clarify. So do you think that 7517 is a doorway to 1.540? Or do you think they're unrelated?
There has been no case law addressing this point.
I guess I would see that as a stretch just because I think it says something about commencing action. Yes, commencing action. And so if
That's a
if
fair
we think
reading.
of
That's a fair
1.5
reading, Your Honor. That's a fair reading. But at least it suggests, in answering Justice Kennedy's question, was that the legislature, notwithstanding what 75.09 says, the legislature contemplated that there was a mechanism for revisiting that finality. And part of where the
what they contemplated here is, by your own admission, is not what you're trying to do. Okay?
No, not under 7517.
You're not covered by this.
I understand, Your Honor.
To the extent, if we did assume that this is kind of a comprehensive legislative scheme, then whatever you're trying to do is outside of what has been contemplated here. It seems like to. I mean, why would that be wrong?
In terms of this particular remedy, well, I agree with you, Your Honor, but there's nothing about
but arguably you're concluded by the other provision we've been talking about that has the forever concluded language or whatever it is. And this doesn't open the door to you because you're trying to do something different than what this could conceivably allow. And so you're just kind of out there in a...
It's a negative implication argument.
I sat through several hours of the negative implication argument, but I'm going to resist the urge to engage it. This circles back to the idea of underlying this whole collateral matters doctrinal discussion that appears in this court's jurisprudence is the idea that Chapter 75 proceedings are, 1, sharply limited, 2, intended to be moved along very quickly so that you get these bonds approved. And as this court has on more than one occasion observed, if you start injecting collateral issues into these matters, you are defeating the legislature's purpose in having a Chapter 75 proceeding. And that's what's at issue here, because you have an egregious overreach. You have FPFA, and it was supposedly, for all publication purposes, supposed to be a garden variety bond validation, engage in a statewide power grab.
But arguably, though, the legislative purpose is served by making sure that there's notice. I mean, in this case, there were people there involved who could have raised these issues, and so the legislature has to balance the benefits of the quick proceeding, the finality, getting the right people at the table to, you know what I'm saying? So you can't just look, you got to, if you're going to look at the purpose overall, you've got to look at the built-in safeguards that they have, too.
Exactly, Your Honor. And in Chapter 75, FPFA is supposed to have given notice anywhere where it is located. So what did they do? They were created in a charter between Kissimmee and Flagler County. However, they know full well going into this bond validation proceeding that they are going to ask the trial court to say they have statewide authority to operate anywhere, however they want, without any level of local government involvement, jeopardizing the homesteads of thousands and thousands and thousands and thousands of Floridians. So if you are going in saying, I know that I want to operate in every county in Florida, and all you do is publish in Leon, Flagler, and Orange, what are you trying to do? Other than, respectfully, to pull a fast one. And they have obtained a series of what essentially amount to a series of declaratory judgments against the 63 other counties that are affected here and the umpteen tax collectors. And let's throw in all the possible municipalities, the 400 some odd municipalities in Florida as well.
Is your position that they failed to comply with any notice obligation required as a matter of law?
It's a great question, Justice Carrillo.
Did they break the law?
Yep. They played with the law.
That's not my question.
No, I understand.
I mean, you're playing. That's
No,
what
no,
we're
no.
here. That's what you guys do for a living.
That's what I do for a
That's why your
living.
suit is nicer than mine, Mr. Geddes.
Why, thank you, Your Honor.
So, but I'm hearing you say that the answer is no. They didn't break the law. Can you identify some notice requirement they failed to hit?
It depends upon how you read the statutory provision that requires them to publish notice wherever they are located. All right? If, admittedly, before the bond validation judgment gets approved, they are located in Flagler County and the city of Kissimmee, because those are the entities that created, those are the members to the agreement, the charter.
And those counties have tax collectors. And,
I understand.
And they have general counsels who are presumably watching the docket, right?
Right.
Okay.
I understand. But what they are asking the court to validate goes way beyond that. And just the concept of fundamental fairness, of due process, of giving parties an opportunity, however flexible due process may be, it at least stands for the proposition that you cannot obtain universal relief against a host of parties and individuals without ever giving them the remotest opportunity to be heard.
I guess my question is, what opportunity to be heard did you lack? This was not done in secret, was it?
Oh, absolutely it was done in secret, Your Honor.
Can you tell me how it was occulted from you?
It was
this was not a matter of public record?
A publication in the Tallahassee Democrat tells Broward County...
I can't Google it?
Excuse me?
I can't Google it?
Why would you Google it?
Well, because there's presumably a tax collector where they're located who is probably affected by this, no?
No. Why would the tax collector down there be affected by it if the tax collector doesn't know that bonds are going to be issued in their county without their involvement?
I guess where I'm at, though, is I hear you saying essentially, no, they didn't break the law. No, there wasn't... No, so I'm not hearing you say that?
I'm not saying the connotation of breaking the law is... I would rather phrase it as a question, did they comply with the spirit of the notice requirements in Chapter 75?
So we've heard spirit of the law and occulted, so I think we should wrap this up. 30 seconds.
I notice I have gone considerably over the time because of the engaging colloquy I've had with the court, and I don't want to take away time from the Attorney General to speak. So thank you for your time.
May it please the court, Kevin Golombiewski for the Attorney General. The heart of this appeal, in our view, is what it means to have the authority to issue a bond. That authority will decide whether the matters that are contested are collateral, and I think it'll help with some of the procedural questions that the court has posed. Under Chapter 75, the authority to issue bonds means the bare authority to act, the bare authority to do the things enumerated in Chapter 75, including impose assessments and remedies for assessments like the uniform method, and also the bare authority to incur debt for the project. In this way, these proceedings are very similar, in our view, to quo warranto proceedings, where the court is concerned solely with whether the state officer has the bare authority to act such that the action wouldn't be ultra vires. And so here, we think that the circuit...
What language does the all matters connected therewith do in circuit court jurisdiction?
The all matters connected therewith language in the statute ensures that the jurisdictional provision 7501 captures all the matters enumerated elsewhere in Chapter 75, including 7504, which talks about the complaint, and 7509. And we think the statutory history illustrates this because the substance of Chapter 75 pre-existed 7501, and 7501 was added to ensure that it was clear that circuit courts had jurisdiction over these proceedings. And so that all matters connected therewith language does work in ensuring that all these other things discussed in the chapter are part of the circuit court's jurisdiction. And I think where we depart from the appellees is the bare authority to act requires just this checklist or box-checking exercise. And so if the circuit court looked at Chapter 163 and said the legislature has granted the bare authority to invoke the uniform method, its job was done. In going further in opining on how tax collectors, where they have discretion in interacting with FPFA, or whether FPFA has to comply with regulations, that was going too far. And another illustrative example, I think, is the recent Richardson case from this court on Corwanto, where the court looked at the ACA secretary's power and said, well, everyone knows that the secretary has the existence or the bare authority to operate a website and post on social media. And so Corwanto is not the right proceeding to talk about whether a criminal regulation and how that might impact the secretary's exercise of power. And so this is a very, we think, clear line drawn through the precedents and through this statute that's focused on the bare authority to act versus the exercise of power, in how and whether localities can regulate FPFA and maybe make its operations more cumbersome goes only to the exercise of power. And that's beyond the bounds of these proceedings historically, which have been these checklist form proceedings where the state attorney looks at the Enabling Act, the charter, the bond resolution, and from those documents, the circuit courts can determine whether there's this bare authority to act. And so with that in mind, we think that there's no tension or no conflict between 7509 and using 1.540 for the narrow purpose of contesting matters that were beyond the circuit court's jurisdiction. So 7509 renders final and conclusive the judgment of validity of the bonds, but the judgment is circumscribed or limited by the scope of the circuit court's jurisdiction. So here, in using 1.540 to challenge only matters that were beyond the circuit court's jurisdiction, or ultra vires, the appellants are not running into 7509's forever inconclusive language. And to Justice Kennedy, to your point about 7517, we do think these things fit together. So 7517 too protects against attacks or allows for challenges to the validity of the bond. And so it's an exception to 7509, which shields these validly adjudicated matters. And it would be an odd reading of the structure of the statute to say, well, 7517 allows individuals to challenge the validity, the heart of the bond, but then the much less disruptive challenge of a 1.540 ruling to clean up these extra jurisdictional procedural matters is not permitted. So even though 1.010, we agree, applies because this is a special statutory proceeding, there's no conflict between 7509 and the narrow use of 1.540 here. It would be a different question if the appellants were using 1.540 to contest the legal validity of the bond in matters that are not ultra vires. I see my time's up. Thank you, Your Honor.
Thank you so much. We appreciate it.
Mr. Chief Justice, may it please the court, Paul Huck on behalf of the Florida PACE Funding Agency. I'm going to split my time 20 minutes and 10 minutes with our co-appellee Fortify. Your Honors, this case begins and ends with the express language of Chapter 75, Article 5 of the Florida Constitution, and Rule 1.010. And because that language forecloses the use of Rule 1.540 as a backdoor plenary appeal of final judgments, which is what we're faced with here in bond validation proceedings, we've asked that this case be dismissed, or if not dismissed, that the court affirm the trial court's order. By way of brief background, I just wanted to touch base on what the PACE program is. Our client uses the word PACE in its name, but PACE is a broader program. It's a Property Assessment Clean Energy Program that the Florida legislature created back in 2010. And through that program, thousands of Floridians have been allowed to make improvements to their homes that include hurricane hardening through the levy of voluntary non-ad valorem assessments. Florida PACE is a local government entity that administers one of these PACE programs. And as was mentioned earlier, Florida PACE validated its first series of bonds back in 2011 under a prior iteration of Chapter 168. At issue today is Florida PACE's 2022 validation of a $5 billion bond issue. It's undisputed that as part of that validation process, Florida PACE complied with all of the requirements of Chapter 75 and 168. That's undisputed. It's also undisputed that the state, pursuant to the express terms of Chapter 75, was represented in those bond validation proceedings by the relevant state attorneys. Trial court entered its final judgment validating those bonds in October 6, 2022. No appeal was taken from that judgment, and by operation of statute, that judgment became finally conclusive. And in reliance on that final judgment, and this is to answer a question that was asked, to date, over $500 million of bonds have been issued under that.
Mr. Huck, can I ask you, what would you concede, if anything, constitutes a collateral matter? What would you be willing to say, even if everything you just said was right and it was included in the final judgment, you would nonetheless concede constitutes a collateral matter?
Well, Your Honor, to get to that point, as you know from our briefing, you'd have to get through all of the rule of finality that's established as a matter of substantive law in Chapter 75, and then also the procedural deference that the courts have to give to the procedure that's kind of inextricably intertwined with that statutory proceeding under Rule 1.010. You'd also have to blow through all of the procedural and substantive aspects of Rule 1.540, which they haven't done here. They kind of brush past that and want to get right to the merits. What would be a collateral proceeding is what is laid out in this court's, or what would be a collateral issue would be what's laid out in this court's precedent on that issue. And so I think, for example,
under, like, let's go way back, like City of Miami is, about how Miami uses its that. So, like, would that be a collateral matter? Do you concede that would be a collateral matter?
No, because what the court did in City of Miami, in the 1958 City of Miami case, because there are a number of City of Miami cases, right. One of them, another one's relevant here. But in the 1958 City of Miami case, the court actually held that the trial court's adjudication of the scope of Dade County's Home Rule Authority was not collateral. That went right to the heart of whether the City of Miami had the authority to issue the bonds it wanted to issue system. So that issue, the application of a county's Home Rule Authority to a municipality's ability to issue bonds has held to be not collateral. And similarly, in Keys Citizens from this court, the court held that determining whether a county ordinance that mandatorily required a hookup to a water and sewer system, whether that was a legally valid county ordinance, was not collateral to the issuance of a bond.
So
because
what
it goes to the heart, right? It goes to the heart of what, to kind of get to this issue of authority versus operation. It goes right to the heart of the validity of these assessments. Can these assessments, as they are described in the bond offering documents and in the financing agreement, are they legally valid? And so that all those issues, and they can be broad depending on the type of bond issuance that's being brought before the court, to the extent those are relevant to that legal validity, those are not collateral, and those are absolutely appropriate, and that's what we have here.
I'm still not hearing an example of what would be a collateral.
I can't. Well, one example that would be one. Let's talk about the City of Gainesville, which we've heard some discussions about. The City of Gainesville was concerned about whether or not it would be able to, or would have to pay back certain funds in the future to the county, I believe it was. And so the court there held, what's interesting about that case is the city was asking to include that in the validation proceeding because it was under the misimpression that if there is something that was not collateral, or was collateral but not included in the bond validation proceeding, it would be precluded from litigating that separately. And the court said, no, that, first of all, that issue is collateral because it's something that could happen in the future. It doesn't go to the present validity, scope, nature, legal obligations that are going to be part of this bond, which then is going to go out into the public market. And if we step back for a second and we think about why is this rule of finality here in this chapter, as this court has recognized repeatedly, that's because of the legislature's desire to ensure the marketability of these bonds. I mean, we're talking about Florida and its public entities' ability to access the public capital and finance market. And in addition, we're also concerned about bondholders who now these bonds are out being traded in the market. And the bondholders need to have that finality to know that they have marketable bonds and securities that they're buying and trading. And so there are things that are collateral. We don't have them here, and in any event, those issues all get adjudicated on plenary appeal. I mean, that's the whole point of the scheme that the legislature has created in 75. It's created an adversarial proceeding where you have the bond issuer coming before a court, you have the state and others represented by the state attorney. That's a legislative choice, which it can make under Article 5 of the Constitution, which tells us what the powers of the state's attorneys are. And that is an adversarial proceeding. It's not an ex parte proceeding.
What if the circuit court had passed on the permissible coupon that could be paid, but not the validity of the bond?
I know about the amount.
Yeah.
The amount of the coupon.
I mean, what if it expressly disclaimed that it was commenting at all on the validity of the security? But it did find that the coupon was the ability of the security, the price at which it's going to trade. What would you say to that?
Well, there's two issues. So just so I understand the hypo is the trial court is finding that the coupon amount violates Florida, and so it is denying validation as to that part.
It says it's a perfectly, the state has the authority to do it. You have the authority to do it. I don't comment on the validity of the statute. It comports with law otherwise, but the coupon, I find, is that a collateral matter? Or is
I don't know the answer to that, Your Honor. I don't know the answer to that. I do know that in some cases before this court, the court has commented that whether a bond is financially desirable to a purchaser of that bond is beyond the scope of the bond validation proceedings. For
like example. The term of the bond would be beyond the scope of it.
Right, exactly. Exactly right. But the point of that is, in the hypothetical you just gave, that is an issue that gets adjudicated in the bond validation proceeding. And so then, if I'm the potential issuer and I think the trial court got it wrong, under the Florida Constitution, I have a right to come here on plenary appeal and ask this court to correct what I think is an error below. And this court could agree or disagree with me. And in that case, then the bond judgment becomes final. And under the operation of 7509, whatever is baked into that final judgment is then what goes out into the market. And that's why we have the rule of finality.
All right. Can you address the argument that 1.01 end of the day, 1.010 is confined to pleadings rather than the procedure and statutory?
Yes, Your Honor, and I do want to say, I think this gets back to my other City of Miami case. In 1915, in City of Miami versus Rumpf, this court held that bond validation proceedings are special statutory proceedings. That's not surprising, I think, to anybody. I think that's a misreading of the rule 1.010, because if you look at the actual language used in the rule, it says the form, content, procedure, and time for pleading. Right? That is not the noun, what is a pleading versus a motion or a paper. That is for pleading. That is how we operate. That is for litigating in front of the court in a special statutory proceeding. And that interpretation or that reading of it in the context of the deference that the court is giving to the procedures that the legislature is creating when it's creating these special statutory proceedings makes sense, and it's consistent with how our Florida courts have interpreted that rule. So, for example, I think the best case on this is a case out of the second DCA, in re commitment of Cartwright. That cites 870 Southern 2nd 152. We didn't provide it to the court because it's in response to the court's question, and in that case there was an issue as to a rule of evidence that the legislature had created for special and specific use in Jimmy Rice in Rice Act cases. It was not a pleading, it was not how you filed your complaint, it's not how you file your answer or counterclaim. It was how is the evidentiary record created before the trial court in a Rice Act proceeding. And the court there noted that procedural provisions in these special statutory proceedings will ordinarily be intimately related to or intertwined with the substantive provisions enacted by the legislature, and that Rule 1.010 provides a delegation of authority to the legislature over matters of procedure in special statutory proceedings unless the Florida Rules of Civil Procedure, and this is specifically provide to the contrary. So it's a deference to not only the substantive law that the legislature creates, but also the procedural scheme that a legislature has the option to create when it's creating one of these special statutory proceedings. So I think that's a misreading. It's an overly narrow reading of the use of the term pleading in the case of 1.010.
Counsel, could you address the notice arguments that the other side has made and how those would potentially affect this sort of idea of finality, that they did not receive notice?
Right. So, Your Honor, as the court is aware, Chapter 75 uses a constructive notice procedure, and this court has specifically approved that and held that is not a violation of either federal or state or Florida version of due process in the Florida Keys case. And if we look at how, and I'm just going to reach over to if we look at how who gets bound by these judgments in these bond validation proceedings, it's exactly that broad language that was spoken about before. The appellants want to just focus on the first part of 7509, and they want to kind of pretend or ignore the very last part of that sentence, which says that the judgment's forever conclusive as to all matters adjudicated, including anyone affected in any way thereby. So what the legislature has done here is create a broad sweeping procedure using a constructive notice, which has been held to comply with due process. And in addition to
But isn't that constructive notice where the parties would be affected? And their argument is you didn't give constructive notice where they would be affected because it wasn't in those counties at the time.
But in order to agree with that, you'd have to ignore that last part of the sentence of what these judgments and who is bound by these judgments. And it's anybody, and that's also in 75.02. It's not just the property owners, it's anyone affected by the issuance of the bonds. And they certainly are claiming here that they've been affected by the issuance of the bonds. And let's also take the next step. So there's constructive notice, but there's also actual representation of the state, because you have the state attorneys who, under the statute, represent the state of Florida. So you not only have constructive notice, but you have actual representation in that proceeding, in the bond validation proceeding. And kind of getting back to first principles about bond validation proceedings, which I think is important to keep in mind as we're considering these issues of finality. You know, the bond, as this court's recognized, bond validation proceedings have no precedent in the common law. I mean, they don't have any ancestor, they don't have any analog in the common law. They are purely creatures of statute. And so, as this court's noted multiple times, for example, in City of Oldsmar, the power of the courts with reference thereto must be found within the statute itself. So we've got to look back to the statutory language in order to find out the boundaries of what the court's power is here. And in 75.0, not only created a judgment that is finally conclusive, but if you look at that last portion of the statute and you see what the legislature has done there, it's not only said in the first part that the judgment's forever conclusive as to all matters adjudicated, but then it goes on to say that the validity of such bonds, any assessments pledged for their payment, and they surely are challenging the legality of assessments made on a statewide basis without entering it on a mandatory basis into interlocal agreements with other local governments. They're surely contesting the legality of those assessments. But any assessments pledged for their payment, the proceeding authorizing their issuance, and any remedies for collection, and this is the legislative language, shall never be called into question in any court or by any person or party.
I guess that's still passed within the context of the Constitution, though. So if we retain, our constitutional writ authority, which through the rules we've, the writ of quorum nobis has now evolved into 1.540. I'm just not sure without 1.010 that writ authority that's given to the courts through the Constitution is dissolved just by virtue of a statute.
But I think here where the legislature is enacting substantive law and is saying the nature of this judgment is unique, and Rule 1.101 says we look to not only substantive but also the procedural law of the legislature, unless our rule specifically says otherwise. And if you put that in conjunction with Article 5's provision regarding this court's jurisdiction for direct appeals only as to that final judgment, all of that means that this attempt to kind of collaterally attack the 1.540 is denied under both substantive law and the procedure that the legislature has created. to get to the 75.17, which is the procedure that the legislature has specifically created, it envisions a separate action with certain kind of safeguards or hurdles that you have to jump over in order to even get into court if you have something that you could think you could bring in the 75.17. That's not a 1.540 motion. And in fact, there is this court, whenever it has been, and I'll talk about Mize in a second, but this court, whenever it has been confronted with an attempt to bring a collateral attack on a judgment, a bond validation judgment, which has become final by operation of statute, has rejected that. If you look at the Steen case, that was a case where someone had filed a motion to invalidate a bond validation after it had become final on the grounds that it was null and void. This court held specifically that the trial court was without authority to consider that motion because of the rule of finality that had been enacted by the legislature. That's also the same rule that the court announced in the Hall case and in the Wright versus City of Anna Maria case. All of those, this court has consistently held that once that judgment becomes final, the legislature's substantive law has prohibited attempts to kind of come in later, claim that something is void, there's a problem with it, and use that kind of motion practice or practice before the trial court to call into question those bonds. There's not a single case involving something other than a plenary appeal to this court under its Article 5 jurisdiction. And that's the problem that they have with Mize. Because Mize was in the context of a plenary appeal. And when we read Mize, we see, yes, someone had filed a motion for a 1.540 motion in the trial court before the judgment had become final. This court, those issues all came up to this court. The court consolidates it. Really with no analysis, it just says there's no question about a jurisdiction. There's no consideration of 75.05, 75.09, 75.02, Article 5. The court just says we have jurisdiction. There's no legal analysis. And then, but even if the court were to say, well, somehow that's a conclusion that we had jurisdiction to hear that in that context, that's on plenary appeal. That's not after this judgment has become final and they're coming in a post-finality situation trying to bring this case up to the court. So Mize really, it's a very slender read and it won't bear the weight that they're trying to put on it. I don't know.
I wanted to ask you about the procedural jurisdiction versus subject matter jurisdiction issue, because I think there's an argument that it's procedural because the court has jurisdiction over the type of case, and so because it's a collateral matter, I guess you have a position on whether this is procedural jurisdiction, and if so, is that voidable or void?
I'm not sure I exactly understand where you're going at, but I think the best way to come at it is what's the remedy they're seeking here? Because what they're really doing, because one of the problems they have is if you got past the finality rule and you said, well, let's even consider 1.540, right? What are they trying to do with 1.540? That's a pretty blunt weapon, so to speak. It's not a scalpel. So what they want to use 1.540 here as kind of to redline the final judgment and excise little pieces of it, kind of like a line item veto. That's not setting aside a judgment. And so they're not, and so what's important to remember is that they're not really arguing that the judgment itself is void. In fact, they concede it's not. They're just saying, well, we think that because it contains things that we think are collateral, we can go in there and ask this court to redline it in the way that we might be able to do on plenary appeal. Right, but we cannot do that using 1.540 as a procedural mechanism. There's not really, so there's no argument that the court lacks subject matter jurisdiction per se over the bond validation proceeding. I don't know if that gets to your concern you're getting at. I don't know if the court has any other questions, but if not, I yield my time.
Thank you very much.
Good afternoon, Chief Justice, and may it please the Court. Olga Vieira on behalf of Intervenor Fortify Financial, Inc. What the appellants are asking this Court to do is something that has never been done, which is to invalidate bonds that have already been issued with debt incurred and financed by private investors. The reason this has never been done is because of the finality built into Chapter 75 and in this Court's 100 years of jurisprudence. Going through the statute, they focus first on Section 75.01, which allows the court jurisdiction to rule on the validity of bonds. But if you move next, and all matters connected therewith, and so they try to make it seem like all matters connected therewith has no definition, but it does. Moving on to 75.02, it allows the court to rule on the authority to incur bonded debt, the legality of all proceedings connected therewith, including the assessments levied to repay the bonds, and the proceedings and the remedies for their collection. So what has happened here is that the lower court ruled that the Florida PACE Funding Agency, FPFA, had the authority to impose assessments statewide. The statute provides for notice to the state attorneys where FPFA is located, which was 2 of them, and the state attorney for the Leon County. And the state attorney is not supposed to just rubber stamp the assessments or the bond validation. The state attorney is charged with examining the complaint, determining whether it's defective, insufficient, untrue, or unauthorized. The testimony in the lower court was that the state attorney reviewed the judgment before it was entered, did not object, and even reviewed it after it was entered and did not object. He did not appeal. There was no appeal of this matter, and once there was no appeal, the judgment became forever conclusive. My client relied on that judgment to spend $210 million in this state, allowing homeowners to make necessary improvements to their home for hurricane hardening and for energy efficiency. What the appellants want to do is inject uncertainty into what should be a very certain process. Investors cannot invest in the bond markets if there is this uncertainty that you can use a rule such as 1.540 to come in and challenge a final judgment. One note on 1.540, it provides that upon such terms as are just, the court may vacate a judgment. And so it's discretionary as compared to Chapter 75's forever conclusive. It's almost redundant in saying forever conclusive, and it shall never be called into question. So when you pit a discretionary ability to vacate a final judgment on terms that are just against a final judgment that shall never be called into question, that final judgment and the courts and the legislature's prerogative to establish a proceeding for bond validation should be held to be final. Going towards the addressing the appellant's argument that the judgment is void because it ruled on collateral issues. I think Justice Sasso, you asked a question about what is the jurisdiction here over collateral matters. There's never been a case where collateral matters were adjudicated after the judgment became final. All of the appeals that the appellants rely on were direct appeals. So once the judgment has become final, the ability to attack it using 1.540 has never been done and has never been authorized by this court. The remedy here is to dismiss this case for lack of jurisdiction. No court has jurisdiction to vacate a judgment once it's been entered. The bond validation is final, and we respectfully request an expeditious ruling because our bonds are at issue and at stake, and it has now been 2 years where the tax collectors have refused to place these assessments on the tax rolls. It's now November 4th, and they still did not place them on the assessments. So exactly what is meant to be avoided by this statute has happened here, where they have injected uncertainty and the bonds are not being collected.
On the disposition, if we conclude that we have jurisdiction because it's a final judgment and a bond validation proceeding, and the general law provides us a jurisdiction to hear, anything that occurred within that action, wouldn't it be an affirmance? Because what you're really arguing is that the circuit court lacked jurisdiction, but that wouldn't necessarily result in a dismissal here.
That would be a perfectly acceptable solution for my client, is that there is jurisdiction, but affirming the lower court's decision that Rule 1.540 either cannot be used in this context or was not appropriately used in this context. Thank you.
Let me see if I can clear up a few things. Chapter 75 works if the procedure and the substance is followed. It's a limited scope. There's a question about who are the parties. 75.05 talks about order and service. The court shall issue an order to the state and the several property owners, taxpayers, citizens, and others having or claiming a right, title, or interest in the property to be affected or to be affected thereby. Those people. Then if you turn to 7506, publication of the notice, it says by this, and this is the notice is just in these in this instance, two areas, Kissimmee and the other member and Leon County. That's the only place. It said, by this publication, all property owners, taxpayers, and citizens or others having or claiming any right, title, or interest in the county, municipality, or district, or the taxable property therein. Those circuits are made parties defendants to the action, and the court has jurisdiction of them to the extent as if named as defendants. My clients did not know. The notice was not in the area. You're going to suggest that they would suggest that if something's done in Pensacola, people in the Keys have to be looking at the public notices there.
What about the state attorneys? Were they not served?
The state attorneys were served in those circuits. But again, the state attorneys, we've cited the statutes, the state attorneys have a limited role for their circuit. That's why it's not serving the Attorney General for the state of Florida, or why they're serving 3. Why do you need to serve 3 if one takes care of all of them? The question about did we know? At the time that this proceeding was in the appeal period, the 30-day period, there was an email that was produced in the trial court from counsel for FPFA to the FPFA saying, when they learn about this, after the appeal period is run, they're going to act shocked. They're not going to be happy with this. They knew that this was, because at the time that this was going on, the reason the attorney was doing this, as part of that email, is Palm Beach was redoing their consumer protection ordinances. Their ordinance such as, before you sign this as a homeowner, you need to see things in bold, or you need to have a right of rescission. Because if you don't pay under this non-ad valorem assessment, you lose your house. We're not saying, they say, we're saying that we're impacted by the bonds, or that we're trying to invalidate the bonds. Absolutely not. We're not impacted by the bonds, and we're not trying to invalidate them. I don't know how many times more we can say that. What we are saying is we're impacted by the collateral matters. And you ask, what are those collateral matters? The collateral matters are...
But it seems like the collateral matter that you're talking about is the assessments. And
No.
It's not the assessments and the enforcement of the assessments.
No. If they had entered it, the collateral matter is that they are taking this and they're saying that Palm Beach County can no longer enforce its ordinance for consumer protection requirements, or any of the other counties that have and use their home rule powers to say, if you want to come in and operate to protect our citizens, we have voted to put these protections in place. They want to say that because of something that happened in Leon County trial court where they weren't noticed, their state attorney wasn't noticed, that they are somehow not, and that issue wasn't even raised or defended, that somehow we're bound by that. The other thing is to tax collectors. The tax collectors have a right under 163.084.
So basically what you're arguing about is not whether they can impose assessments, but the preconditions for entering into the agreements that result in the assessment.
What happened before this, Judge, for 10 years?
Is that right?
Yes. For 10 years, they had their bonds. Nobody complained about it. When they went to Palm Beach or all the other 15 counties, and they entered into an agreement with them, an interlocal agreement. And that's what 163, which is the genesis, that's the Interlocal Agreement Act, said we will comply with all these.
But are you saying that the judgment means that you would lose when you tried to impose that on them, or are you saying that it's not covered by it, or what? You're saying that the way the judgment stands right now, that it's written in a way that it precludes the application of these, what you're saying, unrelated.
That's what this is all about.
Right, I understand.
That they're coming in and saying it doesn't matter that you weren't there because we think these state attorneys in the public.
So you're saying if that issue were litigated in these separate proceedings, that the right answer legally there would be that the side that wanted to impose these things would lose because of this judgment?
That's what they're saying.
I'm asking you if that's the right answer.
They want to say it's res judicata, and we say it's not because we were not a party.
Right, but the judgment covers this stuff. Is what I'm just trying.
The language that they are arguing from, which what they say was very different how they described it to the trial judge. If you read the transcript, they said general law, whatever. is very different than the emails and letters that they sent to the counties afterwards saying, thou shalt not. We're getting rid of our interlocal agreements because we can do whatever we want now. And let me leave you with a couple things. One, the City of Gainesville case from this court says, furthermore, we do not believe that the principle announced in the Lipford case, that's the forever conclusive case, applies to, quote, put at rest, end quote, collateral questions that were somehow brought into the proceedings but need not and should not have been brought in.
Wasn't that a direct appeal, though? The City of Gainesville
It was on direct appeal. Yeah. But the point of the matter is it's having to do with the impact of a collateral issue as opposed to who's bringing it.
Okay, you can have 30 seconds. Okay. You're way over.
And they went on to say it went on to say that the collateral issues treated in Section 20 of the judgment can be raised by proper parties in proper separate proceedings. And then it went on to go, the judgment appealed is affirmed in part and reversed in part, and the case is remanded with that portion. Those collateral should be deleted.
Okay, thank you very much. We're adjourned. Appreciate it.
Thank you.
All rise.